This conference
And,
will now be recorded.
and I was
I'm not
first
able to
impressed.
hear you. Give me 1 minute, please.
Who is
I
this?
don't know what is the problem, but I'm not able to hear you.
Nilesh ji, hello, this is Rekha. Can you hear me? No, I think he's not able to hear anyone.
I think problem is at his end.
Yeah.
Quickly.
Hello. We welcome Nilesh sir, and he's been practicing on this subject, and he is an IP also, CA also, advocate also, and from the firm Dheer and Dheer. And he's been practicing extensively on the IBC matters. With these few words, I request Pragya to introduce Nilesh sir.
Nilesh, sir, are you able to hear us?
Not there.
What should I do? I should.
You at least start the introduction, otherwise.
Nilesh ji, you are not able to hear us? I think there must be some problem in his speaker.
Madam, your voice is absolutely clear.
Yeah, thank you.
नीलेश जी, या तो आप पीसी चेंज करके देखिए या आप स्पीकर चेंज करके देख लीजिए. By the time he's changing, the individual insolvency matters have started rising now. I think after that Jain case, now all the banks have woken up and they are issuing the EOI, our request for the IPs. For I think I must have got around 15-20 or more also. I have lost track of it. But every day we are getting that, and it is better to know the subject from the expert who before jumping into the. So what today we have done is that we have asked anybody has a question, you can write it on the chat box, and we have asked Rekha madam to moderate the session, and then we will keep it as an open house also at the end, but it will be moderated by Rekha madam. Some of the typical issues we face is a right of subrogation, bank guarantee evoke, not evoke. Is there any change in the document? The loan was given 5 years back, the loan documents were changed. So what happens to the guarantee? All these questions are, because the promoter keeps on fighting.
नहीं, अच्छा हाँ. हाँ, प्रवीण जी.
Abhi your voice is clear, sir.
अच्छा हाँ. So I was not able to hear you till now. Only now I have started to hear you. Yeah.
Pragya, please introduce.
Yes.
Hello.
Good afternoon, everyone. It gives me immense pleasure to introduce us our today's speaker, Mr. Nilesh Sharma. He is he's an insolvency professional, and he's the first partner in Triple R Legal Advisors LLP, advocates and solicitors firm, and also in an IPE, R Insolvency Service Experts LLP. And in his academic qualifications, he is a BCom honors graduate from Delhi University, chartered accountant, associate member of institute since January 1992, and fellow member since January 1997, graduate in law since 1997, uh, and he is a practicing legal practitioner in the field of commercial laws for around 30 years and has major experience in the field of recovery, insolvency, bankruptcy, restructuring and reconstruction. He has represented large number of clients including lenders, creditors, acquirers of business, buyers of asset in the distress space before various courts and tribunals including BIFR, NCLT, etc.
I think this
Yes,
is
sir.
sufficient, huh?
Okay, no,
Okay, so I am a chartered accountant.
yes,
I qualified my chartered accountants in '92. Then I did my law, and presently I am practicing as a lawyer and insolvency professional. Okay,
yes.
so I'm having a legal firm and then insolvency professional entity also. So that in brief, that is about me. Yes. So we
Okay.
start today's session, and thank you very much for inviting me.
Thank you,
Yeah.
sir. Over to you. Yes.
And Rekha madam don't need any introduction for our group.
Yeah.
Thank you for such an introduction. Okay.
Yes,
I
Rekha ji.
welcome Nilesh ji. I heard you earlier, and it was a wonderful session conducted by you. So you can add in your list one of the fan. You know, I liked your session that day, so I thought, okay, why not to invite Nilesh ji even in the study circle and hear him out again. So I welcome you here for the benefit of all the participants. Just to start with the structure, what I thought is, Nilesh, let us understand the basic concepts of the insolvency professional, individual insolvency. Then we'll move on to the, having an understanding on the guarantee contract. Thereafter, we'll talk about the subrogation, law of limitation, and what are the jurisdictions, in which scenario the jurisdictions applies, something about the procedures under the individual insolvency, and certain things about the excluded assets and the excluded debts. So these are the prima facie the points which we think we can cover. Subject to the time availability, then probably if time is available with the Q&A round, we can move on to the bankruptcy part also. But today the focus should be on majorly on the insolvency part.
Sure.
So Nilesh, just to start with, I would just request you that if you can give us a little broad framework and the necessity of having the enforcement of this individual insolvency under the Insolvency and Bankruptcy Code, the little bit on the concept of the guarantee as per the Indian Contract Act, the provisions of sections 5, subsection 22 of Insolvency Bankruptcy Code vis-a-vis Rule 3 of DRT. So why I say so, because it's very important for all of us being insolvency professional to know the fundamentals first, and once your fundamental is strong enough, you know that how to work around thereafter. So over to you, sir.
Okay, thank you very much. I am having a small presentation,
Yes.
PowerPoint presentation. I think quickly we go through the same, and then after that we can, I think, make discussion and then question answers and all those things. Huh? So I will upload my PPT.
Yeah, you have got an access to share the screen, sir?
Share screen.
1 minute.
Yeah, one.
Officials from WRC.
Huh.
WRC officials. WRC officials, please.
हेलो
हाँ जरा स्पीकर सर के लिए शेयर स्क्रीन एनेबल करना ना.
हाँ सर, आपको दे दिया, आप शेयर करो डायरेक्ट.
अच्छा आप
नीलेश
निकल
मेरे
गए।
को नहीं, नीलेश सर को,
एक मिनट।
नीलेश शर्मा जी के लिए वो शेयर स्क्रीन एनेबल कर दो। Have you done it?
WIRC official, have you done that? Given the access to Nilesh ji? Nilesh ji, I think wrongly left.
Must be having some net issue or
Yeah, might be.
क्या गायब?
प्रवीण जी अभी फिजिकल मीटिंग चालू कर दो।
Yeah,
प्रवीण जी अभी
Odar
आप
ji,
फिजिकल
you
मीटिंग
are
चल
right.
हाँ
Yes, you
अभी
are
फिजिकल
right.
मीटिंग चालू कर दो।
We thought of that, but Nilesh ji being from Delhi, we thought, okay, let us keep this as a virtual meeting, and maybe from next meeting we can have a physical one.
Yeah, sure.
the last week there was a NESL meeting at WRC. Only 4 participants came physical mode and all others were on virtual mode. There are more than 200 participants. So it is very easy to say that you keep a physical meeting. I don't mind and I will do it also. And we will do it, but then attendance should not be an issue. Otherwise, we call somebody and if only 10 people are there, the speaker also feels very bad. Nilesh Sharma, Nilesh ji is again visible. Sir, are
okay.
you able to share your screen now?
I will share that. I will
Yes,
share
sir.
that. Okay, can you see
Yes,
it
sir,
now?
it is visible. Yes, sir. Yes, sir.
Okay.
Nilesh ji, can you just convert this into the presentation mode?
Okay.
I think it is an.
One minute.
No, on laptop only you will have to do, not in the meeting.
Yeah.
Yeah, something there only you would have.
Yes.
No, it's not showing me.
It's not there, huh?
No.
Okay.
Okay, I think we can continue. This is also clearly visible.
Is it 50? Okay, let me call somebody. Okay, and in the meanwhile, I think we start with this. Okay.
Yes.
एक मिनट हाँ जी okay. So goals of the process of individual insolvency. So one is we start with this goals. So these are the goals as per the Insolvency Law Committee report. So they say that why we need insolvency resolution, individual insolvency resolution process. Okay. So, so these are the goal. But I think before that, let's understand what insolvency is and what is the bankruptcy. What is the meaning of insolvency and what is the meaning of bankruptcy? We have seen that in corporate insolvency resolution process, we are having two processes. One is CIRP, which is corporate insolvency resolution process, and then we have liquidation process. So once insolvency resolution process fails, then we go to the next step, which is liquidation. And in individual insolvency, the first part of the process is called insolvency resolution, similar to the corporates, and then subsequent part is called bankruptcy process. Okay, so here it is not liquidation process, it is bankruptcy process. We don't liquidate the individuals, and we apply this bankruptcy process in order to take over their assets and then distribute the proceeds to the creditors. Okay, now what is the difference? Why the word insolvency and then why this word of bankruptcy and then liquidation? So insolvency, as we all know, that insolvency is a situation or is a condition where a creditor is not able to pay, a debtor is not able to pay its dues as and when they arise. Okay, so this is the definition. This is a situation where somebody is not finding himself in a position to pay the dues which has been incurred by him or it, if it is a company. So then that situation, when you are not able to pay your dues, and it can be because of two reasons. One can be that your assets are less than your liability, and another situation can be where you are having assets, you are having fixed assets or immovable assets, but you are not having the liquidity to repay the dues which are arising in the ordinary course. So what you do is whether both these conditions will be treated as the situation of insolvency. So I think we have to discuss. So you have to tell me whether, when suppose a situation where an individual is having assets worth rupees 100 crore and his liabilities are only 10 crore, but that asset is in the form of a building, 100 crore worth of building, which is not in a position to immediately sell. So whether we will be calling him insolvent? Any reply? Any idea?
He will be treated as insolvent if he is not able to meet his obligation on time. The day it is due, if he is not able to meet, suppose if I have to pay my car installment on 31st March, if I am not able to pay on 31st March, on next day somebody can file an insolvency petition against me, and if I am not able to pay, it may get admitted also. Subsequently, I may pay through repayment plan, but at that date it may get admitted.
Any other view?
Every likely to get it admitted.
Sorry?
Every likelihood of it being admitted if I am not able to pay as on that day, as per the plain reading of the books.
Any contrary view, or all of us agree to this definition, or this whatever Praveenji have said?
Yes, yes.
All of us, we agree to this situation, this opinion which Praveenji has given. So
insolvency is nothing but where the individual would have a financial crunch, the liquidity issue, and unable to pay the debt.
Correct. So now the definition which has been adopted in our IBC, Insolvency and Bankruptcy Code, is based on cash flow, where the liquidity crunch is there and a creditor is not able to pay, a debtor is not able to pay his creditors. Okay, so this is the definition which has been adopted. Earlier, you are aware that before IBC, we were having Sikh Industrial Companies Act. Sikh Industrial Companies Act, the definition of insolvency was based on net worth. So there, the definition was that if the net worth of the company, of an industrial company, that law was applicable to industrial companies only. So if the net worth of the industrial company is negative, or in other words, if its losses are, accumulated losses are more than its net worth, then they were calling it as a Sikh industrial company. Okay, and which was required to go through this process of rehabilitation. We used to call that a rehabilitation process. Okay, so or in other words, we can say where liabilities are more than the assets, then we call that as we used to call that as company as a second industrial company. So our earlier definition was based on net worth or based on the balance sheet of a particular individual or particular company. But now our definition of insolvency is based on cash flow. Okay, so both the definitions have been there. Different schools they adopt different definitions, and one school is that this has to be based on net worth or when liabilities are more than the assets, and another view is that it should be based on cash flow. Now most of the economies or most of the countries, they have adopted the definition which is based on cash flow. So even if your assets are more than your liabilities, but if you are not able to pay your dues, which are much lesser than the total value of your assets, then you will be treated as insolvent and you will have to go through your the insolvency process. Okay, and then now what is the outcome if suppose there is an individual or a company who is in a situation where he is not in a position to pay his dues? Then what should be done? So what should we do? Praveenji?
Sir, I would like anybody else to answer now.
Yes.
Yeah, otherwise Praveenji and myself only will keep speaking.
Correct. So
I would urge that the participant also to have a brainstorming session in the interest of all.
Yeah, especially this is a study group meeting. No, here it is not a
yes.
lecture meeting. So we have invited faculty, expert faculty.
So what should be the outcome of this process, of this situation? What should happen, or what process should be applied? Okay, so I think it will be better if all of us we participate in this discussion. According to me, in this type of a situation, if a debtor is not able to pay its dues, then in that situation, the creditors are entitled to take control over his assets and then get the assets sold, and the sale proceeds should be distributed amongst the creditor as per their respective right. And if something is still left, then that has to be handed over to the debtor. So it is not that all the assets have to be distributed or sale proceeds have to be distributed amongst the creditors. No. So creditors, they are entitled to recover their dues to the extent of their outstanding, and then balance amount has to be returned back to the debtor. Okay, so this should be the outcome. However, what we have done is, or most of the countries, what they have done is that they say that one chance should be given, one restructuring exercise should be made, so that an attempt is made to revive the business or to save the business. Okay, and in case of individuals, to see that if they can settle their dues outside the process, outside the bankruptcy process. Okay, so what for in respect of companies, we are having corporate insolvency resolution process, so which is an attempt before taking over the assets and distributing among the sale proceeds among the creditors. This is an exercise to ensure or to attempt that if there can be any resolution. Okay, so that is why we call it insolvency resolution process. Okay, so insolvency resolution process, we attempt that if we can reach some understanding as to settlement of the dues of the creditors. And if this process fails, then the next step is, in case of companies, that is liquidation, and in case of individuals, if the first part of the process, which is insolvency resolution, if that fails, the next step is same, taking over of the assets of the debtor, and then selling them, and distribution of the sale proceeds among the creditor. So with respect to individual, we call this process as bankruptcy process. So this is the process of bankruptcy, and which is similar to liquidation process. The only difference is that in liquidation, we get the name of the company removed from the register of companies. However, in case of individuals, we give them discharge certificate or discharge order. We allow them to restart their life afresh, to start their life afresh, and they get a discharge from all their past dues. Okay, so we have with respect to companies, we have liquidation process. In respect of individuals, we have bankruptcy process, and both the processes are similar, except one particular difference which I have already told you. And now, so for this insolvency resolution process, initially, you know that in respect of corporates also, we allowed the existing promoters to participate in this process by giving a resolution plan, and which is allowed in most of the regimes in different countries. However, in our country, though in other countries also we are having laws which bar the undesirable persons from participating in resolution process. In our country, we are having section 29A, and which section says that if you are an undischarged, bankrupt or insolvent, and a number of other things are there. And similarly, we have that if your account is NPA for more than 1 year, so that type of condition, disqualifications are there under section 29A. So after insertion of section 29A, to some extent we have closed the insolvency resolution process for existing promoters. But if the existing promoters they are not disqualified by section 29A, then they can also give their resolution plan, and then this insolvency resolution process they can also participate. Okay, so but worldwide this process is normally between the debtor and the creditors, and when debtor fails, like in USA also, so first chance of giving a resolution plan is given to the existing debtor, and if he fails to revive, then public is invited for the purpose of submission of resolution plans. Okay, however, here from the very beginning we invite not only the existing promoter if he is eligible, we invite the resolution plans from public. Okay, and then the highest bidder or the one who gets the highest vote, then he is handed over the particular company. Okay, so these two coming back now, the insolvency resolution, liquidation, and then insolvency resolution in case of individuals and bankruptcy. So these are the processes, and now we come back to the goals. So both these the individual and corporate, other differences are there which we will be discussing later, but mainly these are the processes. Now, goals of the process for individual insolvency: 1, providing a fair and orderly process for dealing with the financial affairs of insolvency individuals. So these are the goals which have to be while drafting the provisions or while making the provisions. So these were the goals which were sought to be achieved by these particular provisions of individual insolvency. So first, one most important object is that the debtor, the defaulting debtor, he should be granted a fair and orderly process for dealing with his financial affairs. So it should not happen that if somebody has defaulted, then you will sell his assets for any amount, and then creditors, because now 100 crore assets worth of assets and debt is only 60 crore. So it should not happen that you sell the assets for 60 crore and that poor fellow, he does not get anything. So he should be provided, it is his right that a fair and orderly process should be provided to him, so that his assets, his financial affairs are dealt with in a proper manner. So this is one of the main objects, and for that reason only you will see that insolvency resolution process, he is provided an opportunity of negotiating with the creditors. He formulates a plan, repayment plan, and then he discusses with the creditors. So in insolvency resolution process for individuals, we don't invite outsider at the first place. Okay, so there still we are negotiating with we are giving an opportunity to the existing debtor to negotiate. Okay, so in that manner, we try to provide him a fair and orderly process. And not only this, even bankruptcy process also we give him, we have tried that a proper process is there, a transparent process is there, and his assets or his affairs are dealt with in a proper manner. Then providing effective relief or release from the financial liabilities and obligations of the insolvent. So this is also very, very important objective. And this objective is that a debtor, if he fails in his business venture, then what should be done? If suppose he has incurred liabilities worth rupees, for example, 100 crore, and his assets are only 10 crore or 15 crore, then what should be done with him? Whether he should be punished with imprisonment, or what should be done with him? So that is the question. So most of the you know that earlier long back, I think insolvency laws have been there, or different insolvency practices have been there for many hundred of years. Okay, so initially they used to punish them. If somebody is not able to pay his dues, so they used to punish him. And then over a period of time, now the insolvency processes or bankruptcy processes, they say they are based on the principle that a business failure is not a crime. If a business fails, if an individual or entrepreneur, he starts a business and that business fails, then in that case he is entitled to a discharge, and so that discharge from those debts which have been incurred by him, which he is not in a position to pay fully. And then after that, so what should be done in that case is that all his assets which are there, except some assets which have to be left with him, so that he should not be put on the road. He still has the right to live his life. Okay, so some of the assets, there are provisions under our law that some assets have to be left with him, so that he can still live his life. And then so taking over all the assets, and then we have to give him a discharge so that he can start his life afresh. So you will see that bankruptcy process, so first insolvency resolution, then bankruptcy process. So bankruptcy process results in an order by the court, and that order says that you are discharged from all your past debts. There are certain debts which are not from which he is not discharged. So those debts are called excluded debts. But most of those debts, so we will see what are the excluded debts. But remaining debts, all the debts, he is given a discharge order, and after that, none of the creditor can reclaim any debt from that individual. Okay, so a discharge order is the final outcome of a bankruptcy process. And then simultaneously, once assets have been taken over by the bankruptcy trustee, so then he will be disposing of, he will be selling those assets, and the sale proceeds are distributed amongst the creditors as per their rights, which are defined under our IBC law. Okay, so this is providing effective relief or release from the financial liabilities. It is very important object of this process, and that is the reason that finally discharge order is passed in respect of individuals. Then providing mechanisms that enable both debtor and creditor to participate with the least possible delay. So the process has to run very there should not be any time which should be lost within while you are running this process, because you know that with passage of time the assets get depleted, the value deterioration is there. Okay, so that is the reason that the time period, this process, insolvency resolution process, whether for corporate or whether for individual, the process should be completed at the earliest, and both the debtor and creditors, they should participate, and participation of debtor is required to fulfill our first goal, which is providing him a fair and orderly process. So that is the reason that we want him, the debtor, also, so that if any residual value is there, that can be given to him, and then he can remain there in this process. He participates in this process, providing the correct ex ante incentives so that individuals are not able to unfairly strategize during the process of bankruptcy. So this is that the debtor should know that what will be the ultimate outcome, and that should be the incentive for him to participate in this process. If he knows that he will not be released of all these liabilities, so then he will manipulate. Okay, so that manipulation or strategy, unfair strategy should be discouraged. So this is the goal of the process of individual insolvency. Ingredients, etc., I think we can skip. Consequences of inefficient rescue regime in India. Notification and applicability. I think you are aware that provisions relating to personal guarantors to corporate debtor only have been notified. So insolvency resolution processes and bankruptcy processes relating to personal guarantors to CD only have been notified. Other provisions relating to partnership firms and proprietorship firms and other individuals have not been notified yet. Okay, so then you are aware of all these, that notification, the rules and regulations have also been notified, and you are also aware that minimum amount of default for triggering of this process is 1,000 rupees, which can be increased up to 1 lakh of rupees. You are aware of the same. Jurisdiction is very important. So who will be having the jurisdiction in individual insolvency cases? So if there is any insolvency resolution process, CIRP process, or liquidation process in respect of the corporate debtor, in respect of whose dues the guarantee has been given by the guarantor. So if that process is going on in some NCLT, then the individual guarantor's matter will also be filed with the NCLT, who is having jurisdiction over the case of principal debtor. Okay, so that means what? That if suppose with respect to a corporate, the insolvency resolution has not been initiated, or after having been initiated, the process has insolvency resolution process has been completed, and then liquidation is also complete. So in these two situations, the matter will be filed. Insolvency resolution process of individual will be initiated by filing an application with DRT, who is having the jurisdiction over that case. In the cases where the insolvency resolution process of the principal debtor or liquidation process is pending before NCLT, then the jurisdiction will be of that NCLT only. Okay, then if suppose, yes, please.
Yeah, the question here is, in case of jurisdiction is, what in case if the application is filed but it has not numbered, or even if it is numbered but it is not heard, it has not come on the board for hearing. That's number one. The second is, what will be the jurisdiction where the CIRP process is already commenced? That means the admission order is passed and the CIRP process is commenced. However, the CIRP process is stayed by maybe NCLT or Supreme Court, whatever. So in these two scenarios, what jurisdiction would apply?
Okay, so actually, in first situation where it is not yet admitted, so now question is whether it will be treated as a pendency of the matter. So according to me, I am of the view that if it is not admitted, then the matter should go to DRT. Though I am aware of, I think some matter where
two cases wherein, at least in my knowledge, there are two judgments which have been passed by different benches, saying that yeah, pending admission is not barring the jurisdiction of NCLT.
Okay. So I think
Bombay is against that. Bombay is against that. Bombay has not passed. Bombay has given the judgment where it is only after admitted it can be admitted.
Correct.
That's what the law also says. So there is a confusion.
Yeah. So actually, you know that different benches of NCLT, they will be having different views, and ultimately, if some final, if NCLT or Honorable Supreme Court they decide, finally this issue will be settled. But I think my personal view is that if you have filed an application, so you don't know whether ultimately this application will be admitted or not. So filing of application, I don't think will be deciding the jurisdiction. Okay, admission only will be deciding the jurisdiction, not filing of application. Okay, so I think we are having different views, but my personal view is this. But we have to see, if suppose the particular case is falling within the jurisdiction of Honorable Mumbai bench of NCLT, then in that case we have to see what has been the view of Honorable Mumbai NCLT. Okay, and so particular NCLT, unless we are having having an order from a higher court, so we have to go by the orders which are passed by different benches of NCLT. Okay, so that is one. Then second situation was that if NCLT process has initiated, NCLT process is going on or it is admitted, and then finally it is stayed by Honorable NCLT or by Honorable Supreme Court. So you know that when a process is, when an order is stayed, so then in that case, it is not of any legal effect. The order which has been stayed is not having any legal effect unless that stay is vacated. Okay,
Yes.
so question is that if suppose the order, NCLT order is passed for admission, and then Supreme Court has stayed that order, so can we get the moratorium? Can we say that the company is under moratorium? Answer will be no, because that order granting moratorium has been stayed by the higher court. Okay, so similarly, if after admission the order of admission has been stayed, one is process has been stayed after admission because of some technical reason. So we have to see which order has been stayed. If suppose admission order has been stayed, then in that case, I think this will not be treated. This will be similar to a situation where application is filed, but it is not admitted. So till the time an application which is admitted is pending before a bench of NCLT, I think we will not treat it as a case where the reference should go to application should go to NCLT.
So in what we are saying is that when there is a stay, maybe by NCLAT or a Supreme Court, the process will process continues, the CRP process continues. Hence, the jurisdiction will not change. The time when the stay is finally, I mean, the admission order is dismissed by the NCLT or Supreme Court, and the CRP process is quashed. Then in that case, the jurisdiction from the adjudicating from the NCLT, it will be transferred to DRT. Am I right?
Correct. Achha, now another thing is that if suppose the admission is there, and after admission the process is going on, and there is some issue relating to the resolution applicant or the process which has been filed for inviting resolution plans. Okay, if at that point of time the process is stayed, then there is a pendency before NCLT. Okay, so we have to see if order admitting the application, if the order admitting the application of insolvency, if that is stayed, then that will be having the effect as if there is no application. But if any subsequent stage there is a stay by a higher court, then pendency is already there. Then question is not whether that application is maintainable or not. There is some other issue for which the stay has been granted, and when that particular issue is resolved by the higher court, then the process will continue. So in that case, if at any subsequent stay order is there, then in that case jurisdiction of individual guarantors case will be with the same NCLT. Right?
Right.
Okay. So now next then if already with respect to an individual, suppose there is no pendency of any pendency of CIRP process before with respect to the principal debtor before any bench of NCLT, and then DRT accepts that application and of individual insolvency, and subsequently the process is initiated before NCLT, then in that case the application will be transferred to NCLT.
Yes.
Okay. Then framework of IBC adjudicating authority. So we are aware that one corporate and non-corporate entities are there. So in corporate we have two processes: insolvency, resolution, and liquidation. And where we have jurisdiction with National Company Law Tribunal, who is the adjudicating authority, and appeal against order of NCLT go to NCLT, and then appeal against the orders of NCLT go to Supreme Court. And in case of non-corporates, so we have individuals and then we have partnership firms. Okay, so partnership firms and individuals we have personal guarantors to corporate debtors, then we have proprietary business and individuals without any business. So individuals, we are having these three classes. So presently provisions relating to the only one class have been notified, and with respect to personal guarantors to corporate debtor, insolvency resolution process or bankruptcy process, the jurisdiction is with NCLT when already there is a pendency in respect of corporate debtor, and rest of the matters the jurisdiction is with Debt Recovery Tribunal, and then appeal against the order of DRT goes to DRAT, and then against any order passed by DRAT we go to Supreme Court. So this is the adjudicating authorities and appellate authorities under law. Differences between CIRP and individual insolvency process. Okay, so these are the differences. One, creditor classification. So in case of CIRP, corporate insolvency resolution process, we have financial creditors and we have operational creditors, but this classification is not there in case of individual insolvency. Individual insolvency, we have all creditors only, and there is no financial or operational creditor classification. Similarly, and in case of bankruptcy also, you know, in case of liquidation also, normally there is no difference, except that at one place I think where at some places rather and especially section 53 we have unsecured financial creditors. Okay, so separate treatment has been given to them, and rest of the section 53 mainly talks about secured and unsecured creditors. Okay, so 53 in section 53, so first of all we have insolvency resolution process cost, CIRP cost, and then we have secured creditors. We are not having secured financial creditors, secured creditors. And so even if suppose some secured operational creditor is there, so he will be having the priority. So secured creditor along with workers for the last 24 months. Then we have employees dues for the last 12 months. Then we have unsecured financial creditor. Okay, so this classification is mainly for the purpose of CIRP, corporate insolvency resolution process. Then interim moratorium. So interim moratorium is not there in case of CIRP. Moratorium starts only when there is an admission of insolvency resolution process by an order of the court. And individual insolvency, the day you file your application for initiation of insolvency resolution, then the interim moratorium is available. Okay, so after that no suit can be filed, or if already there is some suit which is going on or any other legal proceeding, that will be treated as state. Okay, so available interim moratorium is there in case of individual insolvency, and when it is admitted, when individual insolvency is admitted, with effect from that day, we have normal moratorium provisions. Okay, otherwise till that time, till the time normal moratorium starts, we are having interim moratorium, and if it is admitted, then for a period of 180 days the moratorium will apply. In case of individual insolvency, we are not having that extension also. We are not having the provisions for extension, specific provision for extension, as we have in the case of CIRP. So CIRP, we can extend the process by 90 days. However, individual insolvency, 180 days is the period. The role of RP,
So
it
Nilesh,
starts.
saying yeah, just to pause here. So we are saying here that interim moratorium in case of individual insolvency starts from the day when the RP is filing an application along with the repayment plan.
No. It's
not
repayment
that.
plan. No, actually, you know that when this individual insolvency process starts under section 94, when a debtor files an application. Files an application for initiation of insolvency resolution process. So from the day he files this application, this moratorium starts, interim moratorium starts. Okay, and when, and you know that under section 100, admission is made of his application, and then regular moratorium starts, and then after that repayment plan is formulated by the RP, the debtor in consultation with RP. So that is a subsequent stage. Process interim moratorium starts from the very first filing of application for initiation. Okay.
Okay. Yeah.
G. Then the role of RP. Role of RP starts from the admission of application in case of CIRP. So you know that in case of CIRP, the order for appointment of RP is passed on the date when admission is made. So NCLT passes an order. They say that now we are admitting this application, and then they mostly simultaneously, and in some cases even after a few days from admission. So they pass that order and for admission, and then RP's role start, which is interim resolution professionals role starts from that day. But in case of individual insolvency, so you know that there is a provision under section 94 and 95 that you can file that application through a resolution professional. Okay, so your role starts even before that. So he helps the debtor in filing of that application, and through him this application can be filed. Then possession of assets. So under CIRP, you know that from the date of admission of CIRP, the possession goes into the hands of a resolution professional. Okay, so on admission, the debtor, he loses the possession. But in the case of individuals, when bankruptcy process is admitted, from that day only the possession goes into the hands of the bankruptcy trustee. But
So
before that,
during the period of individual insolvency, there is no possession of assets in the hands of resolution professional.
Correct. So insolvency resolution process of individual continues with the possession of the assets, and if he is having some business, he will continue to run that business. But it is different in case of corporate insolvency resolution process. Next is consequence of rejection of plan.
Yes.
Okay, so consequence of rejection of plan is that the company has to be compulsorily liquidated. Okay, so RP is having that responsibility or duty to file an application for initiation of liquidation. Okay, however, in the case of individuals, the bankruptcy process is not a compulsory consequence. Okay, so the court gives option to them, the creditors and the debtor, to file an application before for the commencement of bankruptcy. So that is not automatic. That is not like as is there in the case of companies. Okay, so these are the major differences in these two processes, and I think let's move on to the provisions. Let's see what are the provisions of the insolvency resolution process of individuals.
In what scenario practically when if the repayment plan fails, why would even one will go and file a bankruptcy? What difference it will make?
Sorry. You are saying
I
that
mean,
if insolvency resolution
if
fails.
suppose a repayment plan is made and that fails.
Okay.
So
Then
what are the chances that the creditors will go and file the application for bankruptcy?
okay. So now creditor has to see what are the assets which are available. Okay, and then based on the same, he has to take a call whether he wants to pursue these proceedings. If suppose that as a debtor is not left with any assets, okay, so then in that case he may not like to spend further money, because I think the money and then time also, because if he knows that there is no asset available or a value of the asset is very minimal or negligible, then in that case I think they should not. I think that is the only reason. Otherwise, if a creditor he is aware of the fact that debtor is having certain assets, and he can, by initiating this process of bankruptcy, he can make some recovery, then definitely I think he will be going for bankruptcy process of the debtor. Okay, but in most of the cases we are seeing that in many cases that the debt which are there with the individual guarantors, mostly those are mortgaged with the lenders. Okay, and after those assets are disposed of, then very minimal amount or very small amount of assets are available. Okay, or in many of the cases we have seen that they transfer these assets. They know the debtors, they know, or guarantors, they know that yes, ultimately these proceedings will be initiated, so they transfer these assets to others. They sell those assets, so like that. So but the debtor, there also we are having similar provisions relating to individual insolvency. Also we are having the provisions relating to avoidance transactions. So if they feel that the assets have been transferred by the debtor, so then they can I think initiate, or they should initiate the process, and then they should try to get those assets returned or recovered, and then which can be utilized for repayment of the arrears. Okay,
So it is all the more good for even a debtor to suo motu file for a bankruptcy application. He can file it. The debtor can file it.
Yes.
So
Yes.
it is all the more encourageable that they file it and get the discharge order.
Yes. So many of the people, I think a number of applications have now been filed by individuals, individual guarantors, and reason for the same is that presently they are facing a large number of litigations. A number of applications, a number of cases are going on against them, DRTs, different DRTs, and a number of other recovery actions they face. So what they do is that they in order to get discharge order from the court, they are filing applications. In many cases they file that themselves also under section 94, and in many cases they get the applications filed from through some creditor, friendly creditor. Okay, so objective here is that they can start their life afresh, and then they get rid of all the litigations which are pending against them. Okay, and but at the same time, what I have seen is that different benches of honorable NCLT, mostly they are not rather they delay accepting these applications, or they see them as with some doubt that with the intention of getting some benefit they are coming here, but actually that benefit is provided by law. And even I've seen that in many cases creditors have initiated, various lenders have initiated processes against the insolvency resolution process against the guarantors. But when guarantor files that, then they oppose. They say that this has been done with a fraudulent intention. So according
Yes,
to
maybe
me,
Section 10 application, the way we have in CIRP, is not actually
yes,
seen in a right way by the adjudicating authorities.
correct. And you know that in case of corporate Section 10 applications, if they don't file the application when the company is under a situation of insolvency, so then it is obligatory on them. They must file it. Otherwise, what are they doing? They are doing what we call fraudulent trading or wrongful trading. If a company is incurring losses and is not able to pay the dues of its creditors, then in that case, if it continues with its business, then it is incurring further liabilities. It is taking material on credit from the suppliers. Then workers and employees, they are providing them services, and the promoters or the management of that company, they know that they will not be able to pay to the workers or to suppliers, but still they are continuing with their business. So that is fraudulent, or what we call wrongful trading, and consequences are there under Section 66. So you know that Section 66 here, the wrongful trading, their meaning is that if you know that you will not be able to pay the dues of your creditors and still you are continuing with your business, that is wrongful trading. And in this type of a situation, the debt which you contract, those can be you will be liable for making payment of them personally. Okay, so director can be held liable if you are continuing the business of a company in this type of a situation. Okay, so but when we file application, when Section 10 applications are filed, so then we don't accept them. We say that you are filing it for getting some benefit. If a debtor, corporate debtor, is filing an application under Section 10, I don't know what benefit he is getting. If he is offering, he is saying that take my assets, and then this process, because it is not that he is continuing with the possession over the asset, which he will be taking benefit of. So the situation is different as it used to be in Sikh Industrial Companies Act. In Sikh Industrial Companies Act, the promoters, they were having the possession over the assets, they were running the businesses, and whatever money they were pocketing, whatever money they were earning, they were pocketing. And lenders, they were not able to recover their interest cost even. So they were not allowed, lenders, creditors, suppliers, they were not allowed to recover their dues because there was a moratorium. So that was a situation where the promoters, they were interested in prolonging the proceedings because they were getting that benefit of Section 22(1). But here that benefit is not there, because the day this process is initiated, this application is admitted, you have to lose the possession over the assets. Okay, so I think if any debtor is initiating this type of action, I think that should be accepted by the court. Okay.
Yes.
So now, definition of guarantor under Section 126 of Indian Contract Act. So the definition is, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Okay. So, and then the person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. So this is the definition which is given under Section 126. So three parties are there. One, a guarantor, then creditor, and then we have debtor. So these are the three parties. There can be a single contract, or there can be two separate contracts, one for providing finance and then another can be for the purpose of providing the guarantee. Okay, so but three parties are must. There have to be three parties, and then the liability of the guarantor, it arises only when there is a default by the principal debtor. Okay, so this is must. If there is no default by the principal debtor, then liability of guarantor will not arise. Okay, so let's see what further that liability of the guarantor is co-extensive with that of the principal debtor. Okay, so what is the meaning of this? The meaning is that in case of a default, then both of them are equally liable. The guarantor is also liable, principal debtor is also liable, and creditor can initiate recovery action against either one of them or jointly against both of them. Okay, so if there is a default by a debtor, then the creditor can initiate recovery action against the guarantor first. So it is not that first he has to proceed against the debtor and then only after he has made some recovery from there, then only he can proceed against the guarantor. So he can proceed against the guarantor first, he can proceed against the debtor first and then against the creditor, or jointly also. We have seen that in most of the cases in when we file original application in DRT. So then that is we make both of them as parties. Okay, so that is jointly we file that application for recovery against them, and can be invoked even prior to resorting to the corporate debtor. So as I said, that if there is a default against any one of them, you can against guarantor also you can proceed first. Then definition, which is there under section 522 of IBC, an individual who is the surety in a contract of guarantee to the corporate debtor. So that is, he is a personal guarantor. So this is section 522. Now, so these are some important terms relating to these two processes: insolvency resolution and guarantee, insolvency resolution and bankruptcy. Excluded asset. So as I told you that now we ensure, most worldwide normally, some assets are still allowed to be retained by the debtor, and these assets are here in our IBC section 79 subsection 14. So the excluded assets are defined there, and this excluded assets include: one, unencumbered tools, books, vehicles, and other equipments as are necessary to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation. So these type of assets, like his personal tools, and all these assets should be unencumbered. अगर आपने इनमें से कुछ भी बैंकों को मॉर्गेज किया है या क्रेडिटर को मॉर्गेज किया है, then they will not be falling within the definition of excluded assets. Okay, so excluded assets are assets which are allowed to be retained by the debtor during the bankruptcy process. तो bankruptcy process में हम क्या करते हैं, हम उसकी सारी assets भी take over, bankruptcy trustee is appointed, वो debtor की सारी assets को take over कर लेता है, उनको dispose of करता है, and then money is distributed amongst the creditors. However, there are certain assets which cannot be taken away from the debtor. So these are those assets. So these assets are called excluded assets. Okay, so unencumbered tools, books, vehicles, and other equipments. तो ये वाली जो assets हैं, which are used for personal use or for the purpose of his employment, business, or vocation. Okay, so then these are excludable from the this one attachment and from taking over from him. Unencumbered furniture, household equipments, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. तो उसके घर में कोई फर्नीचर रखा हुआ है, या फिर कोई हाउसहोल्ड इक्विपमेंट्स लगे हुए हैं, या फिर कोई प्रोविजंस वगैरह जो घर का सामान, जो खाने पीने का सामान और वो सब है, तो वो भी इसको भी आप उसको ये नहीं कर सकते कि उसका भी पोजेशन लेके आप उसको बेच दें. Then any unencumbered personal ornaments of such value as may be prescribed or for his immediate family, prescribed of the debtor or his immediate family, which cannot be parted with in accordance with the religious uses. तो इसका मतलब क्या हुआ कि जो वो पर्सनल ऑर्नामेंट जो which cannot be parted with in accordance with religious uses, जैसे कि हम कहते हैं मंगलसूत्र है, तो मंगलसूत्र आप ले नहीं सकते क्योंकि वो उसकी वाइफ की पर्सनल उसके लिए as per their religious usage it is required to be with her, वो आप नहीं ले सकते. Of such value as is prescribed, तो ये वैल्यू हैज बीन प्रिस्क्राइब्ड एज 1 लाख ऑफ रुपीस। तो ये जो वैल्यू है ये अपना हमारे रूल्स में इंसॉल्वेंसी इंडिविजुअल इंसॉल्वेंसी का जो रूल्स हैं उसमें प्रिस्क्राइब्ड है 1 लाख। तो 1 लाख रुपीस तक का
here in this case, Stridhan also would be part of a religious usage.
Stridhan is not treated as part of the property of the that particular of her husband. Stridhan is not liable for attachment.
Okay.
Stridhan is treated as belonging to that lady only. Okay, and here we are not going to take up or take over the assets which are belonging to any other family member. Only those assets which are
family.
No, the assets, suppose uske husband ka asset hai which is used by his wife. Suppose उसको उसने खरीदा है, डेटर ने खरीदा है वो मंगलसूत्र और उसकी वाइफ यूज कर रही है, तो आप उसको नहीं ले सकते। बट और ये लेकिन अगर कोई एसेट बिलोंग ही नहीं करता उस इंडिविजुअल को, बैंकक्रप्ट को, तो वो अपनी वो इसमें कवर्ड नहीं है। हियर वी आर टॉकिंग अबाउट ओनली दोज एसेट्स which belong to that particular individual who is going under bankruptcy process.
But other than Mangalsutra, other jewelry can be attached. Other jewelry can be attached.
हाँ जी, अदर ज्वेलरी कैन बी अटैच। और मंगलसूत्र और ये जो रिलीजियस यूसेस के हिसाब से जो भी ज्वेलरी है वो अप
जैसे
टू
फॉर
1 लाख।
एग्जांपल लोग कड़ा पहनते हैं तो सिक्का कड़ा हो जाता है, तो दैट इज अ रिलीजियस यूसेज।
हाँ,
सो इस तरह से आपको या अदरवाइज अदर ऑल ज्वेलरीज विल बी कंसीडर्ड।
Yes,
but maximum limit is 1 crore 1 lakh रुपए only ना। तुम बोलोगे कि मेरा मंगलसूत्र 5 लाख का एग्जाम नहीं होएगा, 1 लाख तक का ही एग्जाम।
करेक्ट, बिल्कुल करेक्ट कह रहे हो। अगर वो 5 लाख या 10 लाख का कुछ है, so that will be taken away and 1 lakh
is the question.
तो वो 5 लाख का, अगर 5 लाख का 1 लाख कैसे करोगे? 5 लाख का काट के तोड़ के बेच लोगे?
हाँ, for that thing. The question arises is on which date this valuation is to be seen. I mean,
नहीं रेखा, my question is different. I say that if the मंगलसूत्र जब 10 लाख,
अगर 5 लाख का एक मंगलसूत्र है तो उसको बेच के क्या 1 लाख का लेंगे और 4 लाख को एनकैश करेंगे? ऐसा होगा, ऐसा
नहीं, मैं बताता हूँ आपको। देखिए, अगर कोई एसेट है, सिमिलरली नॉट ओनली अनएनकम्बर्ड पर्सनल ऑर्नामेंट्स, आप देखेंगे कि इसमें एक सिंगल ड्वेलिंग यूनिट भी लिखा हुआ है, एन अनएनकम्बर्ड सिंगल ड्वेलिंग यूनिट ओन्ड बाय द डेटर ऑफ सच वैल्यू एज मे बी प्रिस्क्राइब्ड। तो सिंगल ड्वेलिंग यूनिट यानी कि कोई घर, उसके लिए वैल्यू जो प्रिस्क्राइब की है रूल्स में, दैट इज 10 lakh if the house is situated in a village, in a rural area, or if it is in a urban area, then 20 lakh of rupees.
Correct.
So अब suppose कोई debtor, he is living in a house the value of which is 10 crore. So what will happen in that case? According to me, if it is in a urban area, then the asset will be taken over, it will be disposed of, and then he will be provided 20 lakh of rupees. So it is not उसमें से 10 लाख 20 लाख घर छोड़ के बाकी बेच देंगे, नहीं। So he will be provided with 20 lakh of rupees. Similarly, अगर ज्वेलरी कोई 10 लाख की है, उसमें से आप तो केवल इसी वैल्यू तक का वो कर सकते हैं, है ना। तो ये एक सिचुएशन हो सकती है।
और बॉस एक बात बताओ, अर्बन एरिया इज बॉम्बे, अर्बन एरिया इज लखनऊ आल्सो। A house in Bombay of 10 crore and the house that the similar measurement of that house in Lucknow may be of 5 lakhs or 10 lakhs rupees. So how can it be? That is also urban area. Bombay is also an urban area.
तो उसमें तो नहीं, देखिए ठीक है, अर्बन एरिया उसके हिसाब से नोटिफिकेशन नहीं है। Notification could have been based on the different cities, different values. I think should have been prescribed. However, presently in the rules we are having these two values only. कि कोई रूरल एरिया है कहीं भी हिंदुस्तान में तो उस पे 10 लाख रुपए तक का, और अर्बन एरिया के लिए 20 लाख रुपीस का। ठीक है, अब इसमें there is another thing, another interpretation can be, they say that unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. अब उसमें लिखा है कि 20 लाख अर्बन एरिया में है, तो वो कहते हैं अगर एक्सक्लूडेड में केवल वही एसेट होगी जो 20 लाख तक की वैल्यू की है। अगर आपकी 5 करोड़ की वैल्यू की एसेट है तो वो एक्सक्लूडेड में नहीं है, फिर आपको 10-20 लाख भी नहीं मिलेगा। तो देयर कैन बी अनदर इंटरप्रिटेशन, सो दिस इश्यू इज रिक्वायर्ड टू बी सेटल्ड। अभी इस बारे में कोई फाइनल कोई जजमेंट हमने देखा नहीं है। सिमिलरली ज्वेलरी में भी अगर आपने लाख रुपए तक की कोई ज्वेलरी है, हाँ, विच इज मंगलसूत्र, तो दे से कि भाई वो ऐसा कोई मंगलसूत्र है जो अगर लाख रुपए से कम की वैल्यू का है तो वो एग्जेम्प्टेड है। बट अगर कोई 20 लाख रुपीस या 10 लाख रुपीस का कोई है तो देयर द इंटरप्रिटेशन कैन बी देन इट इज नॉट, इट हैज टू बी टेकन अवे। Okay, so we are having.
So can we say when we purchased the Mangalsutra, it was of a 1 lakh rupees. Today it may be of 5 lakh rupees. Similarly, the house. Similarly, the house. Or not the cost price. Not the cost price.
यहाँ देखिए इंटेंशन क्या है। देखिए अगर एक डिफॉल्टर है, उसने 25-30 साल पहले कोई लैंड खरीदा और वो उस लैंड में वो रह रहा है, और वो लैंड सपोज उसका 20,000 रुपीज फॉर एग्जांपल उसने 50-75 साल पहले, आज उसकी वैल्यू 25 करोड़ रुपए है फॉर एग्जांपल। हाँ, तो यहाँ इंटेंशन ये नहीं है कि उसको जो है उसको एक एग्जेम्पशन देना जरूरी है। एग्जेम्पशन नहीं, यहाँ पे इंटेंशन ये है कि ये नहीं कि वो 25 करोड़ के घर में रह रहा है और बेचारे क्रेडिटर्स दे आर सफरिंग। हाँ, तो यहाँ पे इंटेंशन ये है कि some value should be left with him so that he can live his life. It is not कि हम उसको एक पॉश घर उसको देने लगे हैं कि आपने ये 1947 में 1 लाख का खरीदा था तो अभी 20 लाख तक की वैल्यू का है, तो आप 50 करोड़ की वैल्यू है तो आप ले। हाँ
उधर जी, आपके एग्जांपल के हिसाब से he should be shifting to Lucknow. Now what is the harm? He should be having only one adopt to live his livelihood. So he can shift anywhere in India. He can go and buy a house in SRA also.
Yes. तो यहाँ पर इंटेंशन
लखनऊ में थोड़ी ना बिजनेस शुरू कर सकता है। वो जो बिजनेस बम्बई में होगा वो लखनऊ में थोड़ी ना हो सकता है।
नहीं, see, let us not go emotional. कोई कर सकता है या नहीं कर सकता है, it's not the case. What law talks about is taking the money is equal to pay.
When you say that a flat, a house can be sold, so is there any restriction that it cannot be sold to someone? It can be sold to his relative also. Is there any restriction on selling of his assets to anybody?
हाँ जी, there are restrictions. वो restrictions हम लोग अभी आएंगे आगे। तो कुछ restrictions हैं, और देखिए उसके लिए भी अब who will be selling these assets will be sold by bankruptcy trustee, and bankruptcy trustee has to follow a transparent process. And there are certain restrictions कि वो खुद नहीं परचेज कर सकता, कोई क्रेडिटर नहीं खरीद सकता, उसने कोई प्रोफेशनल को एंगेज किया है वो नहीं खरीद सकते। तो ये सब है, स्पेसिफिक प्रोविजंस आर देयर। हाँ, तो अभी हम लोग एक्सक्लूडेड एसेट्स की जो बातें कर रहे थे, तो वहां पे ऑब्जेक्टिव हमें पता चला कि इट इज नॉट कि वो बहुत पुरानी, आज उसकी वैल्यू 50 करोड़ है, हम उसको इस बेसिस पे कहें कि ओके तूने लाख रुपए की खरीदी थी 50 साल पहले तो you retain it, and poor creditors they will continue to suffer. No, तो उसकी वो assets उसको लेके, और उसके जो मैंने आपको बताया two interpretations are possible. अभी we have to see कि finally what is the interpretation. इसका एक interpretation यही आ रहा है कि excluded assets वही होंगी सिंगल dwelling unit जो 20 लाख रुपए से कम की वैल्यू की होगी अगर अर्बन एरिया में है ना। तो ये बहुत ये अकॉर्डिंग टू मी दैट शुड बी द करेक्ट इंटरप्रिटेशन। इट इज नॉट दैट ही शुड बी गिवन 20 लाख एंड देन कहें कि अगर 20 लाख के कम में घर में रहता है तो उसको अलाउ करते हैं, नेवर नहीं। देन वी हैव एक्सक्लूडेड डेट्स।
Sorry to interrupt. I missed that point on Sridhan. Sridhan is a part of the excluded assets?
जी, देखिए मैं आपको बताता हूँ। स्त्रीधन एक्चुअली स्त्रीधन बिलोंग्स टू द लेडीज ओनली, बिलोंग टू द वाइफ ऑफ दैट इंडिविजुअल। इट इज नो मोर द एसेट ऑफ द of the individual, that particular individual who is under bankruptcy. Okay, so it will not be treated as part of his asset and will not be liable for attachment. Okay,
what in case Nilesh, that Sridhan, the lady who has that Sridhan, she herself is a guarantor.
If she goes into bankruptcy, then definitely she will be allowed assets which are listed under section 79(14) only, 79 subsection or clause 14 only. Otherwise, rest of his Sridhan will be taken away from her.
Yeah.
Hello.
Okay.
Thank
I would
अगर
request
इसके दिन
everyone to
हस्बैंड ने
post.
परचेज किया हो तो
I would request everyone to post their question in chat box. As and when each chapter gets over, I'll take up the questions so that Nilesh ji can cover topic by topic. You know, we don't unnecessarily distort the whole discussion. Nilesh ji, please go ahead.
हाँ जी. Now excluded debts. तो अभी तो था excluded assets. Now these are excluded debts. तो क्या है excluded debts? तो excluded debt का मतलब है those debts to which discharge order will not apply. Okay. तो जो कोर्ट जो discharge order पास करती है, that discharges an individual, that particular bankrupt from all his debts except these excluded debts. Okay, so what are these excluded debts and why? What is the reason that these have been treated as excluded debts? Okay, so let's see. So one is, and then another important thing is that you cannot initiate insolvency resolution process or bankruptcy against an individual for default in respect of excluded debts. Okay, तो excluded debt के लिए आप ना तो process initiate कर सकते हो और ना ही those excluded debts are covered under discharge order. Okay, now let's see what these assets are. Debts are liability to pay fine imposed by a court or tribunal. So if suppose there is a court or tribunal who passes an order saying that you have to impose some fine, you have to pay some fine, so that cannot be covered by that discharge order. A reason for the same is that nobody should take advantage of these provisions for the purpose of avoiding making payment of this type of fine which is imposed by any court. Then we have liability to pay damages for negligence, nuisance or breach of a statutory, contractual or other legal obligations. तो अगर कोई damages का कोई आपके against order हुआ है for negligence, nuisance or breach of a statutory, contractual or other legal obligation, then in that case also आपको वो जो भी damages आपके ऊपर impose हुई है वो भी आप नहीं वो कर सकते. ओके, इसमें मेरा एक ऑब्जेक्शन है इस वाले पार्टिकुलर क्लॉज में कि अगर damages are arising out of a breach of a contractual obligation, so then it should be like any other debt, because contractual debt cannot be contractual debt is covered under the discharge order, but damages arising out of this contractual breach, that is not covered. So I think this is according to me it should not be there, but still presently we are having this this is included here. Liability to pay damages for negligence, nuisance or breach of a statutory, contractual or other legal obligation. तो कोई भी आपके ऊपर damages impose हुई हैं, you will have to pay that. Liability to pay maintenance to any person under any law for the time being in force. So अगर divorce के time पे किसी के अगर उसको directions हैं कि he has to pay maintenance to his wife or his children, then he cannot avoid making payment of that maintenance by going into bankruptcy. तो वो इसके लिए भी इनको avoid करने के लिए bankruptcy के provisions को misuse नहीं कर सकता. Liability in relation to a student loan. ओके, तो अगर हम इसको ये अलाउ कर देते हैं तो स्टूडेंट को तो जब आप देते हो तो एट दैट स्टेज ही आल्सो he is insolvent, because students, they are not supposed to have any assets, but bankers are giving them loan in the hope that in future they will be earning and then repaying. Okay, so liability in relation to a student loan is also not covered. Any other debt as may be prescribed. So these are the kinds of, so this is our public policy that the courts, if the courts impose any fine, then that cannot be given benefit of discharge. Okay, so this is fine, damages, maintenance and student loan. Okay, any question here? So with respect to these loans, we cannot initiate the process, insolvency resolution process. हम किसी को लेके नहीं जा सकते अगर किसी ने maintenance इसका ये वाला जो भी default any
No,
other
I
debt
don't.
as rules में
Is there
अभी
anything prescribed?
I think मेरे नोटिस में अभी शायद नहीं है अभी कोई. Okay.
Right, sir.
जी. Now, these are the regulations. You know that regulations have also been notified with effect from 1st December 2019, and certain definition, associate, corporate debtor, resolution process. So these are the resolution process costs also have been defined there. Then very important definition is under this rules, the definition of a guarantor. So earlier we had the definition of personal guarantor, and here guarantor is defined. So guarantor means a debtor who is a personal guarantor to a corporate debtor, and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So important part is that गारंटर के अगेंस्ट आप अगर इनिशिएट करना चाहते हो तो गारंटर की डेफिनेशन में वही आता है जिसके अगेंस्ट क्रेडिटर ने गारंटी इन्वोक कर ली है. ओके, so if you have not invoked the guarantee, then first you invoke that and then only you can initiate the insolvency resolution process. तो ये बहुत इंपॉर्टेंट है कि गारंटी का इन्वोकेशन होना बहुत जरूरी है. तो you know what is the meaning of invocation of guarantee? I think all of us we know. Guarantee invocation means that we have to write to the guarantor, the creditor has to write to the guarantor that principal debtor has defaulted, now you have to make payment of the dues. So this demand notice, this is a kind of demand notice where you ask the debtor, ask the guarantor to make payment of the dues pursuant to the guarantee agreement executed. तो invocation करना बहुत जरूरी है, then only you will be treated as a guarantor. Okay, and then relatives का भी definition है. Now the specific provisions. Section 94, application can be filed by the debtor, and then requirement is that more than 1 lakh of rupees that should be there. Default of more than 1 lakh of 1,000 of rupees. Sorry, 1,000 of rupees. And it should not be, application should not be with respect to debts which are, it should be with for debts which are not excluded debts. And then he cannot make the application, debtor cannot make the application if he is an undischarged bankrupt. He undergone a fresh start process. He is undergoing a fresh start process, undergoing an insolvency resolution process, or undergoing a bankruptcy process. तो पहली बात तो अनडिस्चार्ज बैंकरप्ट का क्या मीनिंग हो? तो अनडिस्चार्ज बैंकरप्ट आपको मैंने बताया कि सेक्शन 138 इज देयर अंडर विच ए डिस्चार्ज ऑर्डर इज पास्ड बाय द कोर्ट. तो जब हम लोग इनिशियल प्रोसेस इज इंसॉल्वेंसी रेजोल्यूशन प्रोसेस, नेक्स्ट प्रोसेस इज बैंकरप्सी प्रोसेस. ओके, तो बैंकरप्सी प्रोसेस में हम क्या है कि वो बैंकरप्सी ट्रस्टी इज अपॉइंटेड. He takes over the possession of all the assets from the bankrupt, and then after that he submits a report to the court, and then court passes an order of discharge. So that is under section 138. वो जो discharge order pass हुआ तो insolvency resolution bankruptcy process start होने से जब तक आपको bankruptcy ये होता है, बैंक्रप्सी डिस्चार्ज ऑर्डर जब तक पास नहीं होता तो तब तक ए बैंक्रप्ट इज कॉल्ड अनडिस्चार्ज्ड बैंक्रप्ट. ओके, सो अनडिस्चार्ज्ड बैंक्रप्ट अगर है मतलब किसी के बारे में बैंक्रप्सी का प्रोसेस इज स्टिल गोइंग ऑन, यू कैन नॉट फाइल ए फ्रेश एप्लीकेशन इफ फ्रेश स्टार्ट प्रोसेस इज गोइंग ऑन. जैसे इट इज सिमिलर टू सेक्शन 11 सीआरपी के केस में हम कहते हैं कि अगर लिक्विडेशन ऑलरेडी चल रही है या फिर insolvency resolution process already going on, then in that case there is another requirement, there is another thing which is that if an insolvency resolution process has been admitted during the period of 12 months preceding the date of submission of application, then also you cannot. So similar provisions are there in the case of CIRP also, कि आपसे जब आप एप्लीकेशन फाइल कर रहे हो उसके लास्ट 12 महीने में ऑलरेडी अगर आपके बारे में कोई इंसॉल्वेंसी रेजोल्यूशन प्रोसेस एडमिट हुई है तो then also you cannot file. मतलब एक एप्लीकेशन फाइल करने के बाद में, एडमिट होने के बाद में, आप अगले 12 महीने तक कोई दूसरी एप्लीकेशन फाइल नहीं कर सकते. Okay, and then
So similarly, when a debtor is named as an insolvent, at which stage he is been termed as insolvent? Whether when the order is admitted or prior to that also he can be said as insolvent.
Actually, insolvent word is ये कहीं पे defined भी नहीं किया है. एक ही only at one place the word which has been used is undischarged insolvent, and that is in the definition of undischarged bankrupt. तो undischarged bankrupt और undischarged insolvent, तो दोनों का मीनिंग सेम ही नजर आता है. बाकी as I said, insolvency, insolvent is a person who is not able to pay his debt. So actually, तो even from going, when he is entering the process, even prior to that, he is insolvent. So he is going into this process of insolvency resolution because he is insolvent. तो यहाँ पे कहीं ऐसा वर्ड ऐसा लिखा नहीं है कि at what stage he should be treated as insolvent और insolvent वर्ड ऐसा कुछ कहीं पे यूज नहीं हुआ है ना?
भेजो मेरे को.
हाँ जी.
So for bankruptcy, it is clearly stated when he will be treated as bankrupt only the day when the order is passed. But for
Correct.
insolvency, it is not treated.
हाँ जी, इंसॉल्वेंट का डेफिनेशन कहीं नहीं लिखा, बैंकरप्ट का लिखा है कि बैंकरप्ट है जब आपके अगेंस्ट ऑर्डर पास हो गया ऑन दैट डे एंड टिल द टाइम यू आर डिस्चार्ज, यू आर ट्रीटेड एज अनडिस्चार्ज इंसॉल्वेंट एंड अनडिस्चार्ज बैंकरप्ट. ओके.
So what is adjudged bankrupt?
हाँ जी, एडजस्ट बैंकरप्ट. वो एडजस्ट बैंकरप्ट तो हुआ जब जिस दिन आपके फेवर आपके अगेंस्ट वो ऑर्डर पास हुआ है.
Okay.
बैंकरप्सी का ऑर्डर हुआ तो you are adjudged as bankrupt. Okay. Then a debtor shall not be, ये हमने कर लिया already. Creditor.
Sir, may I come in? Sir, may I come in?
Yes, yes.
Rajan ji, please post your question. We will take it all together.
No, I wanted to interact on what was being talked about with respect to undischarged insolvent and a bankrupt. It's not a question. I just wanted to contribute to the debate.
Yeah,
okay,
please.
you have 1 minute.
If that is okay.
Yeah, please go ahead.
Okay. So what I personally believe is that insolvency proceedings are started against the individual guarantor. The process is going on. So if all the debts of the creditors are not paid, then ultimately he would remain as an undischarged insolvent, and at the end of the day a bankruptcy order would be passed against him. So whether the individual guarantor against whom PIRP is going on is an undischarged insolvent or not would be known only when the process is completed, when there are certain creditors who are still left out to be paid. Thank you.
Okay, so actually though you are having that opinion, and we all know that yes, undischarged insolvent means what? Undischarged, we treat this process, insolvency resolution process, that with respect to an insolvent only this process is being run. Otherwise, how you will be resolving the insolvency? So the person who is going through this process is insolvent, though but these words have not been defined. So what we are saying is that there is no specific definition, but different interpretation can be made by different people. But this is not, the word is not defined here. Okay. So now the creditors, application by creditor to initiate insolvency resolution process. So a creditor can also do it, debtor can do, creditor can do, and creditor there is an additional requirement that he has to issue one notice, demand notice. And then in that demand notice, he has to give 14 days time period from the date of service of the demand notice to the debtor that he make payment within a period of 14 days. As we are having under section 8, we allow him 10 days time period. Here it is 14 days time period. And if he fails to make the payment within 14 days, then this application can be filed, not before that. Okay. Now, so there is that definition under rules that there has to be the the guarantee should be invoked. Then after that, the requirement is that there should be some unpaid debt. So it is not that only you are, if you have invoked the bank guarantee, sorry, if you have invoked the guarantee and the guarantor does not make the payment fully, okay, so partly or fully, if there is, the debt is still alive, then you can take that guarantor to this process. And now question is that whether this demand notice has to be issued to him again. According to me, yes, because first is that he will not be treated as a guarantor for the purpose of entering into this process unless he has invoked the guarantee. So once you invoke the guarantee and then there is still some debt existing, then you issue this notice, because this is a requirement here. So you issue this statutory notice, and then within 14 days time period, because invocation time period is defined by the agreement. Under that agreement, guarantee agreement, it must have been written that when you are invoking, you will be giving a notice of 10 days, 15 days. So as per that, you will be issuing notice. Okay, so that is
Nilesh,
from
here
there.
I have a question. Whether the financial creditor can invoke for the full amount of lent money from the guarantor, and if yes, in which scenario he can invoke for the full amount, or it will be only to the extent of default amount.
Okay, right.
And whether there will be a recall of loan prior to the claim of entire loan amount, is that possible?
Okay, so now question is that how much money you can demand from the guarantor. So as you know that whenever there is a default, okay, so suppose somebody has taken a loan from a bank and then installment every quarter, suppose for example every quarter there is an installment which is becoming due, and there is a default at first default for a quarter, then the banker starts making efforts for recovery, and then after that, you know that accounts become NPA after 90 days, the accounts become NPA. So what you are doing is that you are following up with the debtor. But if you feel that no, now you have to start taking action, you have to file an application, original application before DRT, or you want to invoke the provisions of SURFACI Act, or you want to initiate insolvency resolution process. So what you will do is that you will not do it for a period of for one installments or two installments. So it is not that if 10 20 more installments have to become due, then for every installment you will be filing application. No, and you can do that only for the defaulted amount. The application you can file, it can be only for the defaulted amount. Okay, so the amount which has not become due, so for that what you do is that you give a recall notice. So that recall notice is given to the principal debtor that you have defaulted as per the agreement which has been entered into, or with the loan agreement, you have defaulted, and you have failed to honor the terms of the agreement. So in terms of such and such clause, we are terminating the loan agreement and we are demanding the total loan amount which has remained unpaid. So this is called recall notice. So we are recalling the entire loan, even the loan which has not become due. Okay, so that when you recall the loan, you say that okay, now we are terminating within 15 days or 10 days, you have to pay the entire dues. So this is called recall notice, and effect of this recall notice is that entire amount becomes due. So now after that, if you want to take some action, if you want to file a recovery, you will be filing for the entire amount. So if you want to go to DRT, you will be filing it for the total amount, and insolvency, then you will be doing it for the total amount. Then after that, when you have recalled the total amount, then you will be issuing a notice of default. You will be issuing a notice of invocation of guarantee. So you can do it for the smaller installments also. You can do it for the total amount. But I think it is better that in place of for every default you are writing to the guarantor, So what you do is that you invoke, you recall the entire loan, and then after that you write to the guarantor that this entire loan has become due now, and there is a default, and you have to now pay the entire outstanding. Okay, so this is, I think, in this manner it should be done, and then this will be called recalling of the loan, and then after that you have to take further action under this issuance of this 14 days notice and all. I think any other question relating to this?
No, I think well answered. Yeah, thank you.
Okay, Rikaji, thanks. Okay, so then this is the requirement, and then you have to file all the relevant documents showing that yes, there has been a default and all that. And these are procedural aspects. Further, section 96 is interim moratorium. An interim moratorium is available the day you file the application. So section 94 or 95, in whichever section you file.
Before you move on to interim moratorium, with related to contracts, if I have some couple of questions.
Yeah, please.
One I have in my mind is what could be the situation where the guarantor is released or discharged? I mean, 133 of the Contract Act.
Yeah, right. So now question is that there are certain actions which, if those actions are taken, then the guarantor stand discharged, and that is pursuant to the provisions of Indian Contract Act. So
yes.
One is that one is that you are aware that we have two types of guarantees. Okay, one is continuing guarantee. So that continuing guarantee is where you say that, which is a guarantee which covers more than one transaction. So that is continuing guarantee. Like you say that there is a particular a supplier of goods is there, and then there is a purchaser of goods or debtor. So that debtor, the supplier is supplying the goods to that debtor, and then the supplier says that I want some guarantee. So then debtor approaches some person, and that person says, okay, I'm giving this guarantee for a period of 1 year. So all the transactions during this period up to a total value of, for example, 10 crore or 5 crore, like that. So all those transactions, so those will be, I'm guaranteeing those. So that is, for each transaction his guarantee is there. So this is continuing guarantee. So there is another kind of guarantee which is one-time guarantee. So that guarantee is when you have taken a term loan. When you take a term loan from a bank, and then there is a guarantor who is giving guarantee of this term loan. So this is one-time guarantee because term loan has been given. If you want to take further bank term loan, then you will have to take guarantee again. So here guarantee is limited to this particular loan which has been given. Okay, and till the time this loan is repaid fully, your guarantee will still be there. However, there are certain exceptions, and those exceptions are that if suppose you are changing the terms and conditions of the agreement without the consent of the guarantor. Okay, so for future transactions it will not cover the future transactions, the transactions which have already been incurred. So this guarantee will apply to them, but for future transaction, then you cannot hold the guarantor responsible if without the consent of the guarantor you have changed the agreement, because guarantor has given the guarantee based on certain terms and conditions. So if you change those terms and conditions, then he stands discharged. Okay. Similarly, if suppose you release the guarantees, if you release the security without his consent, you are releasing the security, or if suppose in case of a continuing guarantee, the guarantor dies. So for future transaction, this guarantee will not the guarantee will not apply to the future transactions. So these are different kind of situations where guarantor stands released. And special important thing is when guarantee terms and conditions for future are terms and condition of that particular transaction or agreement which has been guaranteed, if those terms and conditions are changed without the consent. However, we have seen that bankers, when they give loan, okay, so they have given the loan, then after that they do even restructuring of debt is also done. If suppose there is a default, further debt is also provided, enhancement of dues are also there. So what should be done if suppose enhancement of debt is there? Suppose some initially 20 crore is given, and then after that additional amount of 5 crore, 7 crore at each point of time, you must get the guarantee deed executed for the total amount. So that is one. Second is that all these, if suppose terms and conditions are changed, like the repayment period has been extended. So in normal situation, the guarantor will stand released. But bankers normally they write in their guarantee deed that the guarantor is waiving these conditions. Guarantor is waiving this condition that he will be discharged if any term or condition is changed. So this type of waivers are there. Many things, most of the things where whenever the contract act provides that the guarantor will be discharged. So most of the situations are covered by them. They say that the guarantor is waiving this condition. Okay, so what happens is that once you have given the guarantee, then after that, though they normally prefer, the bankers or lenders, they prefer that whenever there is a default, they inform the guarantor also. Okay, they send a copy of the demand notice to him also. And whatever happens, if enhancement is there or restructuring is there, so normally they insist that guarantor should also sign. So objective is that there should not be any situation where guarantor is released of his obligations. Okay, but in spite of, though they are doing it, but most of the cases they are having waivers in their agreements, where in their guarantee deeds. And so even if suppose you are restructuring, you are changing the terms and conditions, the guarantor will not stand released as a result of restructuring.
Yeah,
Okay.
so we talked about the guarantors when he gets released. So I just extrapolate the situation considering the CIRP process. So assuming if suppose there is a resolution plan and where a creditor agrees to give some haircut and the amount of such dues are reduced to say 30% with the approval of adjudicating authority on plan. Whether such variance will have an effect on the guarantee contract, that's number one. The second related question is, what in case if the plan is submitted by the corporate debtor, that means the promoters, and not the third party? In such situation, whether the guarantee gets automatically extinguished?
Okay. So one is that whether the guarantor stands discharged as a result of approval of a resolution plan, where the resolution plan reduces the liability of the corporate debtor. Okay, yes. So this has been decided. You are aware that Honorable Supreme Court has decided this particular issue. I am having the judgment with me in one of the slides. So in that particular matter, it has been held by Honorable Supreme Court, and that was the plea which was taken by different individuals, individual guarantors, that if in the CIRP debt of the corporate debtor is reduced, then we stand discharged. Okay, so they say that if guarantor is getting discharged as a result of a particular thing, so we are also discharged. Then you have reduced the liability from 100 to 60. Then our liability is also co-extensive. You can't ask us to pay the remaining 40. So if you have reduced the debt of the corporate debtor to 60, then you can, our guarantee can be only our guarantee can be only to the extent of 60. Or they may say that because you have changed the terms and conditions without our consent, so we stand discharged. Okay, so normally this discharge wala thing is covered by the waivers, but the co-extensive thing. So that has been decided by Honorable Supreme Court. They say that because this is through a process of law, that the debt is getting reduced by following this process. So guarantor will not get discharged. Okay, so
that
this
is
is the
in case of Lalit Kumar, I guess, if I'm not wrong.
Lalit Kumar Jain Supreme Court judgment, and where you know that a number of challenges were made to the constitutional validity of the notification of this 15th November 2019 notification, where these provisions were put into force. Okay, so this has been now, so Honorable Supreme Court says that no, you don't get discharged, and the finally the issues which were raised, so constitutional validity of these provisions has been upheld by Honorable Supreme Court. Okay, so so another thing is that your second question was, if suppose corporate debtor settles the dues of the creditors, so what
Yeah,
will,
I mean, if he settles or he submits the resolution plan and it gets approved by the adjudicating authority.
correct. So now you know that corporate debtor, when corporate debtor is now under the possession of the or under the control of the RP. So this plan will be by the existing promoters only, and mostly they are guarantors. So when they are giving the proposal, so what they are doing is that they are saying that normally this condition is there that the liabilities, the guarantees, their guarantees will be reduced to that amount what is being admitted. Suppose 100 crore is the total debt, for example, and they are offering 60 crore. So they say that on payment of 60 crore, our liability will be, we will be discharged. Our liabilities will be, our guarantees will be released, which is reasonable also, because now promoters of the or guarantors, they are bringing in additional money for the purpose of reviving the business of the debtor. So we can't say that okay, you bring money here also, and then we will be charging, we will be recovering money from you. So earlier also, outside insolvency also, you know that settlements take place with the between the creditor and the debtor. So when this type of settlement is there, and you say that one-time settlement is there against 100 crore, you kindly accept 40 crore. So at that point of time, normally bankers, they consider the value of the net worth of individuals also. Okay, so when they decide that amount, they consider the value of all the assets which over which they are having charge, or the individual assets of the guarantors. Considering that, they decide that okay, against 100 you pay us 50 or 60 or whatever. So when you have already considered that while deciding this settlement amount, so you cannot say that again that now first I will recover it from the company and then I will proceed against the guarantor. No. So whenever there are settlements, so the guarantor's obligations also get reduced. Okay, but in case where different entity is coming into picture, some new promoter is taking over the company, then guarantor, Supreme Court has clarified in Lalit Kumar Jain that guarantor will be liable and he can be proceeded against. Otherwise, what is the purpose of having the guarantee? So you are not able to recover full dues from the debtor. For the remaining amount, you have to proceed against the guarantor. But when it is the corporate debtor whose proposal you are considering, so actually these are the promoters only, or the guarantors, they are bringing in money for the purpose of revival and for the purpose of making payment of the dues of the creditors. So you cannot again ask them to pay pursuant to the guarantee.
I think Nilesh, what you was saying about where the promoters are submitting the resolution plan, the guarantee gets discharged. Practically, I think I agree with your view, but generally the COC members don't agree, you know, and to my knowledge, I have not seen such order wherein the promoter would have submitted and would have got discharged from the, you know, the liability of the guarantee. If you have any knowledge about any orders, something has been passed.
Definitely. Actually, when there is a plan by some third party, then they are not releasing. But if it is by the same promoters, then in that case you will have to do it, and then you are considering the value of the this one also. Though in some cases I have seen that they say that no, we will not release the guarantees.
Exactly, that's what even I have personally experienced, where the COC says that you know, we won't agree to that, especially when the promoters submit their plan.
Okay, but
So
in that case, is it not unreasonable on their part that you are asking them that okay,
Yeah.
you first bring the money for the purpose of revival and then we will be proceeding against you? So I think when you are settling with the corporate debtor, okay, then you cannot proceed against the guarantor, though it finally depends on, if you write in the resolution plan, if you force the promoters that you are giving a resolution plan, but in the resolution plan our terms and conditions are that we will not accept it unless you write that we are entitled to proceed against the guarantor also. Then in that case, that what is the incentive, or why should the corporate debtor or the promoters of the corporate debtor, they file a resolution plan and undertake to pay the liability, except a situation where the value of asset is more and the promoters, they want to lose that, they don't want to lose it. Okay, so in that kind of situation, I think they can accept this type of condition. But I think many matters I think I have seen where the debtors, their guarantees have to be released, and which has been accepted also.
Okay.
Then admission, sorry, this is 96 interim moratorium. And interim moratorium, I think two restrictions are there. One is pending legal action or proceedings cannot be continued with. Second is a new proceedings or legal action cannot be initiated. Okay, so these are the two restrictions. So these are available. This moratorium is available from the date of filing till the date when application is actually admitted. Then,
sir, I had one practical case where during interim moratorium, what the person did was that he removed the bank balance and put it into insurance. He removed it from the mutual fund and put it into insurance.
Okay.
Which is, according to me, it is allowed, but it was a transaction done just to avoid the payment.
Attachment or payment. So I think this kind of transaction cannot be accepted. So if it has been done with the intention of defrauding creditors, I think this will not be permitted. Okay, so
how can we say that it is a defrauding creditors? Can we say that he said because my company went away and I have put the money into, I felt that mutual fund is very risky, so I put it in insurance.
No, but during during the avoidance period, if he is entering into this transaction where object is to take the money out of the reach of the creditors, I think that type of transaction can be set aside. Okay, so this
can it be treated as undervalued or preferential? I don't. Just can it be treated?
No, strictly it may not be. Strictly it may not be because you are not making any payment to any creditor. But at the same time, here your intention, what you are doing is that you are, for the purpose of avoiding attachment or for the purpose of avoiding making payment to the creditors, you are moving the money from one asset to another asset. Okay, so this can be, but ultimately this call has to be taken by the concerned court. According to me, this can be utilized. This money can be utilized for the purpose of making payment of the dues of the creditors. So ultimately an NCLT order will be required for that. Okay, so then section 96 interim moratorium, then submission of report by resolution professional. 97 and 98 is relating to appointment of insolvency resolution professional. So normally the resolution professional which is proposed by the debtor or creditor, that is appointed as the resolution professional, and then resolution professional has to examine the application which has been filed by the debtor or creditor as the case may be, and then based on the same he has to submit a report before NCLT that as to whether the conditions which are there in the section 94 and 95 they have been fulfilled, and based on that recommendations. So this is this is 99. The RP shall examine the application within 10 days of its appointment and submit a report to the A recommending for approval or rejection of the same. Okay, and then we have section 100. Section 100, Honorable NCLT, based on that report, will be passing an order admitting or rejecting the application. And if it is admitted, then they will be issuing directions to RP to start the negotiations between the debtor and creditor. And then, so this from here, the process, real process starts. And after that, the resolution professional and debtor, they have to, so let's see, some other provisions are also there. Withdrawal of the application, so it can be permitted before the admission on the request by the applicant, but if it is admitted, then that 90% thing is there, that the creditors, 90% of them, they have to admit, they have to they have to approve withdrawal of the application. So withdrawal of application is also possible. If some 94 or 95 application has been filed, that can be withdrawn also by the applicant, and before admission and after admission, both the stages. Section 101. So once section 100 order is passed, then section 101 is that moratorium, normal moratorium will start. Here is the same moratorium is there, except that one additional condition is there, and that condition is debtor shall not transfer, alienate, encumber or dispose of any of the assets or his legal rights or beneficial interest therein. Okay, so prior to this admission under section 100, this restriction is not there, but once admission order is passed, that he cannot transfer, alienate, encumber or dispose of any of his assets. So this is the difference between interim moratorium and moratorium. In interim moratorium, first two actions these first two clauses will apply, but in case of moratorium, third one is also applicable. Public notice. So similar to CIRP, the public notice is made for inviting claims from the creditors, and then creditors have to register their claims with the resolution professional, and then resolution professional has to prepare a list of creditors, and this list of creditors, it has to be prepared within 30 days from the date of the notice by which the claims are invited. After that is, once this application, once this list is prepared, then after that, next step is repayment plan. Section 105, debtor shall prepare in consultation with the RP repayment plan containing a proposal to the creditor for restructuring of this debt. So here is that. So here we are calling it a repayment plan. Okay, and in the CIRP process, we call that resolution plan. Okay, so difference is that mostly here we are here business may or may not be there, but in the case of CIRP, normally resolution is based on continuation of business of the company. Okay, so the term repayment plan is there, and this can be based on if there is any business, then that can continue, or it can be based on realizing the assets and then paying the creditors, administer or dispose of any of the funds of the debtor. So these are the, so repayment plan will be like resolution plan, except that if business is not there, then mainly it will be consisting of how the payment will be made, how much time period will be there, how much different classes of creditor, how much payment will be made to them, what percentage of principal will be paid to them, how much time period will be there, what interest rate will be there, and whether what assets he will be selling. So all those things are there. In regulations we have in regulations we are having all those details as to what should be included in the resolution plan and all, as we have in the case of we have section 30, regulation 37 in case of CIRP. Then this report which is prepared, the RP shall be making a report, which is to be submitted to the NCLT, and this is with which will be recommending as to whether the resolution plan, which the repayment plan, whether that should be considered by the creditors meeting, that should be approved by the creditors meeting, or it may say that creditors meeting is not required to be convened. So this recommendation will be when, if he feels that all the creditors, 2, 3, 4 creditors are there, all of them have given their written consent, then he may say that there is no creditors meeting required. Otherwise, he will propose that creditors meeting is required. And once creditors meeting is required, then he will be convening the creditors meeting, and these are the provisions relating to meeting of creditors, notice period and all, mostly similar to this one, COC meetings. Voting rights, all the creditors in proportion to their in proportion to their outstanding. And resolution plan, here requirement is still 75%. In case of company, for approval of a resolution plan, 66% is the requirement. Here it is 75%, and there 66% of those who, of all the creditors, or of all the voting power. Here it is 75% of those who actually vote. Okay, so this is another difference between these processes. And here voting rights, associate of the debtor, he will not be having any voting right, similar to what is there in CIRP. Rights of secured creditor in relation to a resolution plan. It is important, and it is different from CIRP process. Here the secured creditor, if he can decide either to participate or not to participate in the voting on a repayment plan. If he decides to participate, then it will be assumed that he forfeit his right to enforce his security during the period of repayment plan. So if he cannot say that I will be voting on repayment plan, but at the same time during this period I will be selling my security. So a secured creditor can decide that he does not want to participate in this process, and he will be realizing his security separately. So that right is given to him, that he can decide not to participate in this process. In bankruptcy, he can sell his assets separately, but here moratorium will still be applying to him. Okay, but he can decide to vote or not to vote. If he decides to vote, then in that case, one, that he will be forfeiting his right to enforce his security. Okay, or still, if he says that he wants to participate, and he has to give an affidavit stating that he proposed to vote only with respect to unsecured part of his debt, and then he has to give an estimation of unsecured part of his debt also. Okay, so secured creditor can vote, or he can decide not to vote. But if he votes, then he has to vote in respect of either unsecured portion, or if he is voting in respect of secured portion also, then he forfeits his right. He cannot enforce security during the insolvency resolution process. 75% of the creditor, more than 75%, they have to approve. So here words are not 75% or more. So if plan is approved by 75% of them, then plan is not approved. The plan will be approved only when it is more than 75% because of the language which has been used. Contents of repayment plan, then I think purchase of assets by certain persons. So there are certain restrictions, as in the resolution, professional cannot purchase the assets. Professional appointed by him cannot purchase the assets of the debtor. Creditor cannot. Any company where the guarantor or creditor is a promoter or director, associate of the guarantor, creditor or resolution professional, they cannot purchase the assets in this process. Report of meeting. So once the meeting of creditor is convened, and then he has to submit a report before the NCLT. He has to inform the not NCLT, adjudicating authority, whether it is DRT or NCLT. In these cases, mostly it will be NCLT. So then he has to give a report as to whether the plan has been approved, and if plan has been approved, so based on the same NCL, the adjudicating authority will be passing a approving the resolution repayment plan. And if not, if suppose he recommends that no, it is not approved, then in that case the process will be closed, and then the creditors or debtors, they will be allowed to file for initiation of bankruptcy. Then with the adjudicating authority, completion of repayment plan. So once the repayment plan is approved, then after that, under section 114, if repayment plan is approved, then two situations can be there: that the payment has been made as per the repayment plan. Second is the payment is not made as per and there is a default. So if repayment has been made as per the repayment plan, then section 117 will apply, and then RP has to then give a report as to completion of repayment plan. Okay, so this will be circulated. This report will be noticed, and a copy of report has to be circulated by the RP to all the creditors, and a copy has to be given to the adjudicating authority, stating that yes, plan has been repayment plan has been implemented. Okay, so once repayment plan is implemented, then court will issue the discharge order. Here also there is a discharge order which is under section 119. So when the debts have been paid as per repayment plan, then discharge order is passed by the adjudicating authority. Then if it is not fully implemented, if there is a default, then what happens is under section 118, repayment plan coming to end prematurely. So in this situation, then RP has to file a report with the adjudicating authority, and based on the same adjudicating authority allows the creditors whose debts have not been paid fully to file an application for bankruptcy. Okay, so these two situations are there. If payment is fully paid, then discharge order. If not, then order. The adjudicating authority allows the creditors whose dues have not been paid to file an application for initiation of bankruptcy. So 119, I have already told you, discharge order. Then this is relating to, now we come to the landmark decisions. So now we have seen the process. The process is that admission, the registration of claims, preparation of list of creditors, then after that formulation of resolution plan, then after that creditors meeting. So here it is not committee of creditor or is smaller committee of creditor. The committee is consisting of all the creditors. Okay, so all the creditors have to vote, and then if they approve the repayment plan with 75% majority, so that is then approved by adjudicating authority. And if the payment is made as per the same, then discharge order to the debtor. If payment is not made as per the plan, then the bankruptcy process. And if resolution plan or repayment plan is not approved, even then the next step will be that debtors and creditors, they will be allowed to proceed for bankruptcy. Okay, so this is the insolvency resolution process. Bankruptcy process is subsequent process. Let's see what are the landmark judgments in this.
And also here, before we move to the landmark decisions, I would just prefer that we a little bit discuss about the law of limitation in terms of a couple of questions I have in mind. Such as like covering the limitation aspect when the creditor is not able to initiate the IBC on guarantor. Can you explain with some examples that what are the implications if the principal debt is time barred? What is the impact of moratorium in CIRP on limitation? Does it actually give a fresh life or it gets extended? What exactly is the law of limitation to be counted, the period to be counted, since there are many dates which are involved, such as like date of default, date of recall notice, letter or given to the guarantor, etc. So whether it starts from the date of breach or from the date when the surety is crystallizing the amount, or from the actual demand of payment, there must be some exclusion period also, which also needs to be understood. So if you can little bit talk about the law of limitations, I think all the participants will have a lot of clarity about it.
Okay, though we are having 2-3 judgments on this. One is relating to one is this one, Deepak Bhandari versus Himachal Pradesh State Industrial Development Corporation. So this is a Supreme Court judgment. Similarly, we are having this another judgment. So both these judgments, they deal with the limitation part as to from which point of time the limitation starts against a guarantor. And then we are having another judgment, which is this one, Lakshmi Pad Surana also. Okay, so these are the 3 main judgments which deal with the this limitation aspect. So let me explain that limitation in case of a principal debtor and the guarantor. So in case of a principal debtor, limitation starts from the date of default. Okay, so suppose we take an example that if suppose the debtor principal debtor commits a default in 2010, okay, and then we are having a guarantee. The debtor, the creditor is also holding a guarantee from a guarantor. Now 2010, when this default is there, as I told you earlier, that when a default occurs, so default is with respect to 1 installment or 2 installments. So then you have to first recall. So when you recall, you make the entire debt due. So entire debt becomes due when you recall, and you are saying that recall is what? That you pay you have committed a default, I'm terminating the contract, you make the payment of entire dues within a period of 10 days or 15 days. Okay, which is based on the agreement. So when the 10-15 days time period expires, so your limitation will start from that day. So in case of a recall, and if suppose you have not recalled the loan and your loan is becoming due every month, okay, and for the next 5 years your loan is becoming due, okay, so then in that case with every default your limitation is there, your limitation is getting extended with every default. So if suppose 5 years period is there, then in that case your limitation will start from the last installment which has fallen due. Okay, so it is not from the first installment, last installment, you, because each default is giving rise to a this one giving rise to a each installment or each default is giving rise to the that cause of action arises on with each default. Now when you recall the entire loan, so then on one date this entire loan become due, and that is your date of default, and from that day when you say that make payment 15 days, then from the 16th day your limitation starts. And 3 years limitation period is there normally for the purpose of filing of a recovery suit, and even for the purpose of initiating this recovery, initiating CIRP process or insolvency resolution process against a debtor. So 3 years from that point of time. Suppose in our case 1st January 2010 is the date when that recall notice time period is expiring. So till 31st December 2009 the debtor was asked to make the payment, he failed, and 1st January 2010 the now default 1st January 2010, from that day our limitation period starts, and it will continue for a period of 3 years, that is till 31st December 31st December 12. Okay, so on that day this will become time barred. So this is against principal debtor, but at the same time if the this limitation gets extended if certain events happen. And what are those events? One, that there is some acknowledgement of debt in between. Suppose in 2012 in 2012, 31st December 2012, if he admits the debt or acknowledges the debts, he says that, okay, I'm acknowledging that your debt is such and such as on that day. So then because on that day acknowledgement is there, then from that acknowledgement, further 3 years time period is there. Okay. Then if suppose there is further transaction in between, if the debtor during this 3 years period makes some payment in the account, then your extension, your limitation will start from the date when this payment has been made, next day from that day. Okay, so these events have the effect of increasing your limitation period. Now let's talk about the guarantor. So guarantor's limitation does not start on 1st of January 2010 in our case, because when a default is there, then only the creditor has to invoke the guarantee. Invocation of guarantee is what? Invocation of guarantee is that kindly make payment because the debtor has defaulted, principal debtor has defaulted, so make payment within a period of 10 days or 15 days. So when you recall, when you invoke the guarantee, rather, when you invoke the guarantee from the guarantor, then in that case, whatever time period you give in that, if you are giving 10 days time period, then from 11th day, the limitation will start for the guarantor. But invocation of debt is possible during the period your debt is alive. So if debt is alive against the principal debtor till 31st December 2012, you can invoke the guarantee on any day on or before 31st December 2012. So you must invoke during that period. So if on 31st December 2012 you issue a notice which has to be received by him during the limitation period, you issue him a notice to the guarantor that your principal debtor has defaulted, so make the payment within next 10 days period. Okay, so this is invocation. So 31st December 2012, that means till 10th January we have given him time. From 11 January 2011, 11 January 2013, this limitation will start against the guarantor. So 3 years from that day. Okay, so rule is invocation has to be made during the period. Invocation against guarantor has to be made during the period when debt is still alive against the principal debtor. So if principal debtor debt is alive till 31st December 2012, then till that time you can invoke the guarantee. But if suppose on 31st December 2012 admission is made, acknowledgement is made by the debtor, then for a period of 3 years, further 3 years. So then because debt is still alive for next 3 years, so you need not invoke the guarantee on 31st December 2012, because your claim against the guarantor, your claim against the principal debtor will remain alive till now 31st December 2015. Okay, so till that time. So acknowledgement of debt has the effect of increasing the limitation, not only for the debtor, but also for the guarantor. Okay, so in our case, as I told you, that if it is acknowledged on that day, then 3 years time period for invocation is available to you. And then against guarantor, when you have invoked it, and after that you are giving him some time period, so from that time period limitation will be there. Now see what this judgment says. Deepak Bhandari, in this judgment, Honorable Supreme Court says, the right to sue under a contract of indemnity or guarantee would principally arise when the indemnifier or the guarantor fails to pay the money claimed from it, and not from the time when the recall notice is served. Okay, so when he fails to pay the money claimed from him, तो गारंटर का जब आपने उसको इन्वोकेशन किया है, उसमें जो टाइम दिया है जब वो एक्सपायर हुआ है, ये नहीं कि आपने रिकॉल नोटिस, अगर प्रिंसिपल डेटर को रिकॉल नोटिस दिया वो भी नहीं, या फिर रिकॉल नोटिस आप इन्वोकेशन को भी अगर आप रिकॉल नोटिस भी बोले, तो जिस दिन आपने वो किया उस डेट से आपका ये नहीं होगा जो आपने टाइम दिया वो जब एक्सपायर हो रहा है तब से. So while making the demand for payment, no period is stipulated within which the payment should be made. Breach occurs or right to sue accrues when the demand is served on the guarantor. अगर आपने उसमें कुछ टाइम पीरियड नहीं लिखा है तो ये जब आपने वो डिमांड नोटिस उसके ऊपर सर्व कर दिया गारंटर पे तब से 3 ईयर होगा. Then this is another judgment, Supreme Court versus Channa, Virappa, Valerie and others. Supreme Court held the limitation as to guarantor's liability depends on the terms and condition of contract, and such limitation starts running only when actually a demand for payment is made and was refused by the guarantor. Okay, so same thing कि 10 दिन का आपने टाइम दिया उसको और उसने नहीं पे किया. However, such a demand should not be time barred against the principal debtor. तो जब आप डिमांड कर रहे हैं उससे, जब आप गारंटी इन्वोक कर रहे हैं, then it should be a live claim and cessation of operation of accounts cannot be treated as refusal to pay by the principal debtor. The live claim cessation of operation of accounts cannot be treated as refusal to pay by the principal debtor. Then a guarantor's liability depends upon the terms of his contract. If the debt has already become time barred against the principal debtor, the question of creditor demanding payment thereafter for the first time, यहाँ पे लिखा है for the first time, मतलब इन्वोकेशन आपका तभी हो सकता है जब तक कि डेट जो है प्रिंसिपल डेटर के अगेंस्ट टाइम बार्ड नहीं हो गई है. आपने फर्स्ट टाइम वो 31 मार्च 2012 तक आपने फर्स्ट टाइम आपने नोटिस दे दिया, उसके बाद आपको 3 साल अवेलेबल है. बट जो फर्स्ट नोटिस जाना है वो तभी तक जाना है जब तक वो डेट अलाइव है. When the demand is, if the claim is a live claim, that is a claim which is not time barred against the principal debtor, limitation in respect of the guarantor will run from the date of such demand and refusal or non-compliance. Where guarantor becomes liable in pursuance of a demand validly made in time, the creditor can sue the guarantor within 3 years, even if the claim against the principal debtor has become time barred. तो हमारे केस में जैसे मैंने आपको बताया 31 दिसंबर 2012 को इन्वोकेशन हो गया अगेंस्ट गारंटर. ओके, बट प्रिंसिपल डेटर के अगेंस्ट 31 दिसंबर 2012 को डेट टाइम बार्ड हो गया. इसके मतलब हुआ उस डेट के बाद क्रेडिटर कैन नॉट प्रोसीड अगेंस्ट द प्रिंसिपल डेटर, बट ही कैन स्टिल प्रोसीड अगेंस्ट द गारंटर बिकॉज गारंटर का लिमिटेशन अभी 3 इयर्स के लिए बचा हुआ है. तो these are 2 judgments on limitation. Similarly,
so,
I think
what in case if the financial creditor has the mortgage property as security and 3 years of limitation period is over for initiating the proceedings against the individual guarantor? So how do you see in this case what will be the limitation period?
Okay, for invocation of for enforcement of security interest in case of mortgages, the time period is 12 years. Okay, so you can enforce your security, you can proceed against realization of the security, but you cannot file a suit because for filing of suit limitation is 3 years. For initiation of CIRP limitation is 3 years. So if your 3 years limitation period has passed, then after that you cannot take him to insolvency resolution process, you cannot take him to DRT for the purpose of determination of dues and then recovery of the same. Your only option will be, suppose you are having a debt of 100 crore. Okay, so you cannot recover 100 crore debt from him. Your security value is 20 crore. So you can go to the court and you can get this 20 crore asset realized through the process of the court because you are having a mortgage. Okay, so for mortgage you are having time period of 12 years, but for other purposes it is only for 3 years, right?
Okay, so enforcement of security is open for 12 years. The servicing can be done for till 12 years. However, initiating the proceedings, the period will be 3 years.
DRT or CRP is 3 years. Then it was held. This is another judgment, which is Lakshmi Pad Surana. This is very recent judgment. Honorable Supreme Court settled the issue of applicability of Section 18 of the limitation to applications for initiation of insolvency proceedings under the code. It was held that when a principal borrower or a corporate debtor acknowledges the liability a fresh period of limitation is required to be computed from the time when the acknowledgement was so signed by the principal borrower or the corporate guarantor, provided the acknowledgement is before expiration of prescribed period of limitation. So same thing, that if acknowledgement is there, then from the date of acknowledgement, your limitation extends. Okay, so these are the judgments relating to, these are the judgments relating to this one, limitation. So there are certain other judgments. This is Ram Kishan and others versus the state of UP. So here Honorable Supreme Court said that you can proceed against the guarantor first. There is no necessity that you have to proceed against the principal debtor. Okay, then this is Faro Alloys Corporation. You are aware of the same, that here also Honorable NCLAT held that it is not necessary that you have to initiate CIRP process against the principal debtor, and then only you can proceed against the guarantor. And in this, against this order, appeal was filed before Honorable Supreme Court, which was dismissed. Okay, then Vishnu Kumar Agarwal versus Piramal Enterprises. In this particular case, issue was that whether for the same amount of claim and for the same amount of default, you can initiate CIRP process against two persons, one corporate debtor and another guarantor, or both the guarantors. So here the Honorable NCLAT replied to this question in negative. They said no, if one application has been admitted based on your the default, the same amount of default, you cannot initiate, you can file applications, but if one application is filed, then another application will have to be kept pending. So this was the view of Honorable NCLAT. This matter is still pending before Honorable Supreme Court, and there is no final settlement of this issue, though Honorable NCLAT has given a contrary view in this particular case, where Athena Energy Ventures Private Limited Company, in this matter, though liquidation proceedings in respect of another debtor, corporate debtor, were pending. So that was that corporate debtor was guarantor for the dues of Athena Energy Ventures. Actually, in Athena Energy Ventures, my name was proposed by SBI as the insolvency resolution professional. However, subsequently NCLAT said that no, the guarantor who is the RP who is there in the case of liquidation, liquidator, he will be appointed as RP here. So State Bank of India is having in this particular case, Athena Energy Venture, NCLAT has given a contrary view, has taken a contrary view to this particular judgment. Vishnu Kumar Agarwal. Okay, so Vishnu Kumar Agarwal, they said that for the same amount of debt, no two admissions can be made. Here they have admitted, and rather they have said simultaneous remedy is central to a contract of guarantee, and where principal borrower and surety are undergoing CIRP, creditor should be able to file claims. Claims is one thing, but admission of debt is another. So in this particular case, admission has been made, and Athena Energy Venture is under CIRP presently, though liquidation proceedings in respect of another entity, which is a guarantor to the same debt, is still going on. Deepak Bhandari, I think we have already discussed. This also we have discussed. Lalit Kumar Jain. Lalit Kumar Jain, you are aware that where this was constitutional validity of this notification of personal insolvency resolution for personal guarantors and bankruptcy was notified. So here the question was that whether the approval of a resolution plan in case of a corporate debtor has the effect of releasing the personal guarantor. Honorable Supreme Court said no. Court referred to Maharashtra State Electricity Board judgment along with other judgment and clarified that approval of a resolution plan does not ipso facto discharge a personal guarantor of a corporate debtor of her or his liabilities under the contract of guarantee. As held by this court, the release or discharge of a principal borrower from the debt owed by it to its creditor by an involuntary process, that is by operation of law, or due to liquidation or insolvency proceedings does not absolve the surety of the guarantor of his or her liability which arises out of an independent contract. It was held approval of a resolution plan relating to a CD does not operate so as to discharge the liabilities of personal guarantors to CDs. Okay, so this is the judgment, Lalit Kumar Jain, very recent judgment. And after that only you know that this insolvency resolution process of these individual guarantors has been taken up by the courts and CRT. So I think with this we can conclude, except that if you are having some further questions, we can discuss those.
Sir, your views on subrogation?
Subrogation, yes, correct. Yes, it is very important. Sorry, I missed that. Subrogation, let's consider a situation where
you may cover novation of the contract also along with subrogation. So these two aspects, if you can cover.
Subrogation, and second is
novation of the contract.
Okay. Okay. So now question is subrogation. So subrogation, in case we take some example, and that example is if a debtor is under insolvency, corporate debtor is under insolvency, and creditor is having a claim of rupees 100 crore against this corporate debtor. Okay, and then we are having one guarantor also, and guarantor, corporate debtor files a claim against the corporate debtor, and then the different situations we consider. So one situation is we consider the situation where when this insolvency resolution process is going on against the principal debtor, but the creditor has been able to make some recovery from the guarantor. Suppose the lender or creditor is able to recover 40 crore of rupees from one of the creditors. So what should be done? So whether the creditor also can file a claim in the CRP process of corporate debtor for an amount of rupees 40 crore, because he subrogates into the shoes of the creditor to that extent. Okay, so here answer is that whenever our bankers they enter into agreements, guarantee agreements, they waive this requirement of subrogation. They say that till the time our dues are fully recovered, you will not have this right of subrogation. Okay, so till the time this 100 crore rupees are fully recovered, so this subrogation is denied pursuant to the contract between the creditor and the guarantor. So they say that this 40 crore you cannot file your claim unless we are able to recover full. Now question is that because 40 crore has been recovered from the guarantor, so whether the creditor should reduce its claim to 60 crore because 40 it has recovered, and then proportionately then he will be getting the money out of insolvency process or liquidation process of the corporate debtor. So question is whether he should claim 60. My answer to the same is no. My answer to the same is because once creditor recovers 100 crore, then balance money, if he is able to recover more, then creditor is liable to make that payment to the guarantor, because this is not the debt of the guarantor. Guarantor is only a guarantor. Debt belongs to the debt is of the debtor, and guarantors are normally entitled. They are entitled if they are able to make payment, if they are liable to make payment, or if they make any payment, they are entitled to recover from the debtor, which is called subrogation. So they step into the shoes of the creditor and they become liable. They become entitled to make the recovery from the debtor. But in this type of a situation where that right has been denied, but still creditor should, in place of claiming 60 crore should claim total 100. Now question is that what will be the benefit for the same and whether legally it is tenable? According to me, yes, it is legally tenable, because your claim, you are a creditor for 100 crore only, and now you have recovered from him, and if he is made entitled, or if he is allowed, then total debt will remain against the corporate debtor, total debt will still remain 100, and that is the debt of the debtor. Principal debtor's debt is 100 crore only. So if you are reducing your claim, and suppose the secured creditors, they are getting only 60% or only 50% of their dues, for example. So if you claim 100, then you are able to recover 50, and 40 you have already recovered, so you will be able to recover 90. But if you reduce your claim to 60, then you will be entitled to recover only 30 crore, and then 30 plus 40, so you are losing 20 crore. Okay, so actually your claim is that much, though you have recovered some money from the guarantor, but still your claim, your debtor is for full amount, and remaining actually to the extent of 100 crore, if you are able to recover, you will be retaining that. If for any reason, if suppose he is able to recover 40 from the guarantor, and in this process he is able to recover 80% of the dues. So against 100 he gets 80, and 40 he has recovered already from the guarantor. So the banker will be having how much? 140 crore.
Rajan bhai, can you please mute yourself? Rajan bhai, please mute yourself.
Yeah.
Yes, Nilesh.
G. So if you are able to recover, the creditor is able to recover 80, and 40 he has recovered from the guarantor. So 120, then he is liable to make payment of 20 crore to the guarantor. Okay. So the creditor should make a total claim against them. Another thing is, if suppose the lender or the creditor is able to recover total dues from the guarantor, 100 crore the creditor is able to recover from the guarantor, then guarantor steps into the shoes of the creditor. He becomes entitled to all the securities which the creditor was holding, and then he is entitled to file a claim of rupees 100 crore, and then whatever recovery he makes. So if he is able to make recovery of 80, so then against 100, so he loses 20 crore only, and he is able to recover 80. So subrogation, if the total dues have been paid to the creditors by the guarantor, then that clause in the guarantee deed which prohibits him from competing with the creditor, that goes, and then he can file a claim there. But till the time the dues of the creditors are fully recovered, he cannot, pursuant to this particular clause. Okay, so in that kind of a situation, as I said, that total claim should be made by the creditor, and then if any recovery is made over and above the total dues, then he should share that with the this one.
But Nilesh, this is fine, but you look at from both the people's point of view. I mean, their books of accounts. One is the financial creditor who has received 40 crores from the guarantor. He has to adjust to the extent of 40 crores. So he has to show his balance to the extent of 60 crores. How can he actually put up a claim of 100 crores? Second thing is, guarantor has paid 40 crores. He has a debt in his books to the extent of 40 crores, which he has to recover from the corporate debtor to that extent. So he has to put up a claim. So I mean, if only a FC is going to put up a claim to the extent of entire debt, both the books of accounts gets completely, I mean, it doesn't show a correct picture.
Rekha ji, no, it is not correct that it is not reflecting the correct picture. Kindly see that when there is an agreement between the creditor and the guarantor, that creditor cannot compete with the guarantor cannot compete with the creditor, then he is not allowed to file his claim, and then creditor is entitled to recover any money. If suppose we allow the creditor, if suppose this type of clause is not there, if this type of clause is not there, then what happens is that the creditor files a claim for 60 crore and guarantor files a claim of rupees 40 crore. Okay, so total claim against the debtor is still 100 crore, which is actually the debt of the current of the corporate of the principal debtor. So total claim against him is total 100 crore. Only because there is this type of clause between the agreement between those two, we should treat that 40 crore debt which has been paid by the guarantor, that should not be treated as a debt against the principal debtor. I think that will be totally incorrect. Second thing is that if both of them, as we said that both of them they file the claim 60 crore 40 crore, so against 60 crore, suppose both of them they get 40%. Okay, so what will happen is 60 crore he gets 24, against 40 crore he gets, guarantor gets 16 crore. So total how much money they have got against 100 crore? Only 40 crore. Creditor has got only 40 crore from the guarantor, and still, because still his debt is not fully recovered, so this entire 40 crore will be going to the creditor only. This will not go to the guarantor. So whatever money is recovered by the guarantor, by the creditor from the guarantor, that belongs to the creditor unless and until his debt is fully repaid. Okay, so now we have to, now question is that if banker has recovered 40 crore from the guarantor, so where he should keep it? Why, is he not entitled to adjust it? My answer is that we have to do our accounting pursuant to the, based on this legal positions. If I incur a loss by making this adjustment now, and then another thing is I am having that responsibility that that if anything is recovered over and above my total debt, then I have to pay it to the guarantor. Then why should I reduce my claim to this one? And even if suppose I reduce it to 60 crore for based on my books of accounts, then this 40 crore claim also is entitled to make Bishop on behalf of the guarantor, so that against the debtor total debt remains 100, because debtor has not paid anything. Debtor is liable to make payment of 100 crore. So only because creditor guarantor has paid, your debt is not getting reduced. You are still liable to pay 100 crore. So that is my view on this particular thing. Though accounting issues, this particular issue will be there, but I think we have to change our accounting based on this particular legal position. If you lose money because of our accounting, wrong accounting, I think we must rectify that. Okay, another situation can be that if you are able to recover 60 crore from the debtor, and then after making recovery from the debtor, you proceed against the guarantor. So now question will be how much debt you can claim against the guarantor. So now whether you can claim 100 crore, I think in this type of a situation it is beneficial for them to claim 100, but I think legally they cannot. Here 100 crore, out of 100 crore they have been able to recover 60. So your claim against guarantor is reduced to 40 only. So then if the guarantor's liquidation insolvency process, you get 40%. So against 40 you will be getting only 16 crore. Okay, so in case of a guarantor's insolvency, which is after the insolvency after the recovery from the debtor, then in that case, I think your claim, you should reduce your claim, but not in the other situation. Achha, now another important question is that if a resolution plan is approved, and in the resolution plan debt is reduced to 100 reduced to 60 from 100, okay, and then the creditor will be proceeding against the guarantor, and he is able to recover some dues from the guarantor. If suppose 40 crore he is able to recover from the guarantor, so then whether the guarantor can proceed, he steps into the shoes of the creditor, whether he is entitled to this right of subrogation against this debtor. My answer to that is no. And even Honorable, this has been decided by, I think, Honorable, I'm not sure whether Supreme Court has decided this issue.
Nilesh, can you just repeat this example? You are saying if the resolution plan is approved And out of 100 crores, say 40, out of 100 crores, say 60 crores is recovered by the financial creditor.
Yes.
So, and then he is moving to the personal guarantor.
So against the personal guarantor, he will be making a claim of 40 only, because actually, so only 40 crore.
Yes.
Okay, so this
but if
issue,
it is vice versa situation, you are saying that FC will make 100 crores.
Reason is the debt is of the corporate debtor. That is not of the guarantor. Guarantor is only guaranteeing that, and that is the reason that, because that is not his, that is the reason that he is given the right of subrogation. Okay, that difference is there. Achha, now question is that once this now whether after approval of a resolution plan, when the debt has reduced to 60 crore, okay, and creditor is able to recover from the guarantor 40 crore, then whether right of subrogation is available to the guarantor, answer is no. This has been held by Honorable Supreme Court, yes, in the case of SR Steel Limited also, and there was Lalit Mishra versus Sharon Biomedicine, that was the NCLAT judgment. So therein they have clearly held, and in SR Steel Supreme Court has held that the guarantor, because now all the in insolvency or in case of liquidation, what you do is you consider all claims, and then you consider against those claims, you consider all the assets available with the company, and the new promoter who is coming, based on the value of these assets, he is distributing the money to all the creditors. And then when he has offered to pay, when he has provided, he is providing you the value of his valuation of the assets of the CD. Okay, then after making payment of that consideration, he cannot be asked to pay any other consideration. So after that, that is the reason that all the liabilities, other than to the extent which has been proposed to be paid by the new resolution applicant, all those liabilities are waived. Okay, so if liabilities are 100 crore and the new promoter, his valuation is 40 crore, and creditors, they approve his value which he is offering. Suppose that 40 crore proposal is accepted, so that means this 40 crore is the consideration which is being paid by the resolution applicant. He cannot be asked to pay more money than this, because that is the valuation according to him, and that proposal has been accepted. So any liability of the company over and above this 40 crore has to be reduced to nil. Okay, so you cannot, the principal debtor, including the contingent claims, all the claims against the company, they get reduced to nil. Okay, so this right of subrogation is not available after approval of a resolution plan to a guarantor. Okay.
Yeah.
Novation, in what context you are asking? Novation, I think if you are entering into a resolution plan is approved, then it's a renovation of all the liabilities. I don't know in what context, what other context you are asking me about.
Novation, I was asking with context of the the contract when the guarantor is getting discharged. I mean, if suppose the third party is involved and the resolution plan is approved.
Yeah, same thing, yes. So when a resolution plan is approved, okay, so then creditors, then whatever terms are there in the resolution plan, so those terms and conditions, that is nothing but the novation of their earlier agreement. Okay, so whatever terms and conditions are mentioned there, earlier terms and conditions, they cease to be of any effect. Okay, so these terms and conditions, the relationship between them will be governed by this novation of the transactions.
Okay.
Anything further?
No, I think.
Just a quick question. Am I audible?
Yes, connect. Yeah,
Yes.
please.
Yes, sir. Just a small question. Just in case of a resolution plan or resolution applicant has put in a plan stating that he would want to take over the personal guarantees, also of the corporate data or the securities which are with the financial creditor. In that case, will the resolution applicant be able to take over the assets which are available in the personal guarantees, or they cannot take over the personal guarantees under the under a resolution plan?
Okay, so you know that
I'm sorry.
So you know that
The yeah,
yeah,
that he may know that there are personal guarantees also of the principal owner or the owner, the promoter, owner, directors of the corporate data. In
okay,
which case he may actually want to take over the securities which are lying with the financial creditor. So what is his
okay.
standing? Like, can he actually claim the assets of the personal guarantors, or will
I
that
will.
also be a part of the personal insolvency?
Okay, okay. So personal guarantors assets are not part of the CRP process. Okay, and those assets cannot be dealt with through a resolution plan, which is being sanctioned in respect of a corporate debtor. However, if the resolution plan can be based on acquisition of the debt of the secured creditor by any entity. Okay, so if a resolution plan is that one resolution applicant is coming and he says that my entity is there, my NBFC is there, or I am having some ARC. So all these lenders, I am paying such and such amount of consideration to the lenders, and lenders will be assigning all their debts in favor of my ARC, and I will be making payment of the dues of ARC over a period of 5 years. So if this type of resolution plan is there, so then all the rights of the secured creditors, including the guarantees which are held by them, those will be assigned in favor of the of that particular ARC or NBFC, and then the ARC will be having benefit of those guarantees. They can then recover. They can then get those assets of the individual sold by following a process of law and then recover their dues. Okay, so otherwise the dues of the assets of the guarantors are not covered. However, through this mechanism, you can get the get the guarantees transferred to a nominee of the resolution applicant. Okay, correct?
Yeah, thank you, sir. I need clarity on that. So basically, the resolution applicant, if it's a corporate and not an ARC, they cannot deal with the personal guarantees under the CIRP process unless it
Yeah,
was an assignment of a debt through an ARC
correct.
or via a resolution plan. Is what, they could have
That
managed to follow the process of law to recover their dues in such a case. Is
you are
my
right.
understanding right?
Yes, yes, yes.
Thanks,
You
sir.
are right. Okay, thanks. So shall we close the session today?
Can I just two small points from my side, just to add value,
Right.
just two small points. I'll not take more than a minute, if allowed.
Yeah,
Yes,
please,
Rajan.
please.
Aja. So I want to bring to the notice of my August gathering, there is a judgment of NCLAT, and this NCLAT judgment is of 12th August 21. So what is happening is, at least at Mumbai NCLT, at the very initial stage, even before taking the report of the RP, the NCLT has been admitting the matter for PIRP. So in this judgment, NCLAT has mentioned that default is to be considered at a stage of section 100 and not at the stage of section 95, and therefore the order admitting the guarantor for PRP has been stayed. So in the sense that the NCLT cannot admit the case for PIRP before the report of the RP, because if it is already admitted, then the RP is not independent enough to submit his report. When the matter is already admitted and the default is proved, what is there for the RP to report in his report? So that is what is the stand of the enclave. One. And second thing, I just want to give clarity that see, when we were talking about 3 years and 12 years, so as per schedule attached to the Limitation Act for enforcing of mortgage, the period is 12 years under Article 62. But courts have held that you are not enforcing a mortgage when you come for insolvency proceedings. So for insolvency proceedings, the residual article of Article 137 applies, which carries a period of only 3 years. Therefore, when we are talking in terms of insolvency matters, even in case of mortgage properties, the limitation period will be 3 years and not 12 years. Thank you.
Yeah.
Okay,
Thank you,
Rajan
Rajan.
Rajan ji, for the purpose of enforcement of security, you cannot go to NCLT. Okay, so NCLT, for the purpose of NCLT filing, limitation period is 3 years only.
Yes.
Okay, so you cannot go for
No,
this
sir,
one.
for enforcing, sir, or for enforcing, you have to go to a court other than NCLT. I was just giving the logic. The Article 62 applies when you are enforcing. So when you are coming to NCLT, you are not enforcing a security. You are coming for the CIRP resolution process.
You
Yes,
are right
Rajan.
that Article 137 will be attracted, and which gives us a time period of 3 years for the purpose of making reference to insolvency, this one, IBC or NCLT. Okay, so wonderful. I think
we'll take up the last question now, as the time is over. Somebody has put up in the chat box quite long. The question is, if bankrupt person purchased jewelry in his wife's possession and the same is not purchased by his wife, then what will be the action, since on paper this is the property of husband being in insolvency process?
okay. So, but asset is now owned by the husband.
Yeah, that's what the question says.
Asset is owned by the husband.
If the bankrupt person purchased the jewelry in his wife's possession and the same is not purchased by his wife, that means it is purchased by himself, then what will be the action, since on paper this property of husband being in insolvency process?
Yeah, so if it is the property of the husband and it can be proved based on the documents, I think that the jewelry will belong to the husband only and will be covered under the bankruptcy process. He will have to part with this, except that his assets, he can, if suppose that up to a value of 1 lakh of rupees, some Mangal Sutra or anything is there, so that can be saved, but otherwise other jewelry cannot be.
Rekha ma'am, I also had put a question. Can I request to get an answer for that also, please?
Nilesh, are you okay to take up a question now?
No problem. Yeah, please.
Yes, yes, just go ahead.
Yeah, so sorry for the last minute thing. Very simple question, sir, that if there is a single dwelling and it is in the joint name of both the debtor and his wife, let's say if it is worth 1 crore rupees, so how exactly this will be taken care of in terms of excluded assets?
So now the question is that it is in the joint name and their share. Now we have to see whether the share is demarcated. Okay, so if it is, then in that case, the portion which belong to the husband, that will have to be sold. Okay, but if it is a flat and it cannot be sold, so then this difficulty will be there. Okay, this is a practical difficulty where you may not be able to sell that, or you will be able to sell it. The husband only will be purchasing in the name of some other person, so that it will be that kind of situation. If their rights are not, it is undivided property. Okay, they are not having their separate earmarked portions. Then in that case, the authority, they will have to get it separated. They will have to get it demarcated, and then only they can dispose it off. So I think, or there has to be some kind of understanding with the debtor and his wife, who is the part of. If they cooperate, then definitely I think they can sell, and part 50% of the share will go to wife and 50% will go to husband. So that this is this type of difficulty we have seen. That one asset is owned by husband and wife both, and their share is not clearly demarcated. So then in that case, you will have to get that demarcation done, and then only you can dispose of.
Sir, I can add it. We had a similar case and we had prepared a plan. In that case, what we had done, there were two houses, both were in the joint name. So one, the wife share also we offered it to in the repayment plan, and one we kept total house, because anyway, suppose the value is 1 crore rupees, 50 lakhs belongs to the wife. In another 50 lakhs, 20 lakhs is allowed. So only 30 lakhs problem was there. So 30 lakhs, wife said, okay, I will pay it from my other asset. You allow us to keep the house property. Some practical solution was worked out.
Yes.
Yeah, Praveen, but in your case, you had two houses. What in case if there is only one?
But then other cases, the wife, suppose she has some money, she can give it and she can say that, okay, now the entire house may belong to me, or we will continue to have this house.
Yeah.
Or some exempted of assets, like suppose some insurance policies there, we can say that, okay, I will encash that and give it to you, but allow us to keep the house. Some via media has to be worked out. See,
yes.
Ultimately banks know that if they go into litigation, they will also not get it. And the corporate guarantor who is there, guarantor, personal guarantor, he also wants a proper house to stay in.
Even undivided portions are can also be sold. So there are certain buyers who will be purchasing your undivided portion, and it may also happen that one of the family members may purchase that.
But ultimately, some via media, like I suggested, was the only best alternative to do.
Yeah. Yes. Right.
See, ultimately, at many cases where the personal guarantor, they are above 55, 60 years, and they want a house and they are ready to buy it at whatever cost it is. So, any other questions?
I don't see any more questions in the chat box. So we can think of ending today's session. Praveenji, I would just propose you to give a vote of thanks to Nileshji.
Sir, I had already requested Rajan sir. Rajan sir, please propose the hearty vote of thanks. It's better a lawyer propose a vote of thanks to a lawyer. Rajanji, are you there?
Hey, I am there. Okay.
Yeah, please,
so
please,
friends, you will all agree that we had a very learned speaker today in Shri Nilesh Sharma ji. He has taken us through all the provisions of personal insolvency, and he has also explained the judicial pronouncements in very simple language. At the end of the lecture today, we all stand enlightened because of the efforts of our learned speaker Nilesh Sharma. I propose a hearty vote of thanks for him, and I request all of you to carry it by a loud applause.
Also, a very hearty vote of thanks to our moderator, Madam Rekha Shah.
Thank you so much
for moderating the session very well, for asking a pointed question and controlling the discussion. Okay, so we conclude. Achha, before we conclude, anybody interested in taking any next session? And what is your view on the physical meeting? I will propose physical meeting, but then members should come. It should not happen that only 5-6 people are there and we invite some speaker and we just waste the time then. See, physical meeting is permitted, and we had earlier 4 years we had physical meeting. So now also physical meeting is allowed, but members should come. What are your views?
Really, I'm exiting now. Thank you very much. Thanks.
Yes, sir. Yes, sir. Thank you very much, sir. Thanks a lot.
Thanks.
Thank you so much for your time given to us.
सर ये क्वेश्चन ग्रुप में पूछ लीजिए फिजिकल रखना है कि वर्चुअल रखना है?
नहीं
क्योंकि
सर,
हार्डली
क्या
एनी
है?
मेंबर्स आर लेफ्ट.
Okay, what as you suggest. What are the views of the members present here? And I don't mind keeping it physical, but then there should be good attendance. Otherwise, किसी को speaker बुलाया तो
प्रैक्टिकल प्रॉब्लम आने ही वाला है। लोग बोलेंगे फिजिकल रखना है, 4-5 लोग बोलेंगे, बाद में आधे से ज्यादा लोग वर्चुअली करेंगे। ये
तो there
थोड़े
is no
समय
point in अपन 2-3 जन जाके physical meeting करें, because once we say physical, at least 4-5 of us will have to be go there personally, and after going there we feel that nothing is there, so we wasting our time and nobody is there.
मेरे ख्याल से वर्चुअल मीटिंग ही ठीक रहेगा सर.
Okay, anybody, any other opinion?
Rathi ji, virtual meeting is advisable, but only